ডাস্টবিন তো করে দিবে হ্যাঁ। No case for interference is made out, reputation is dismissed.
Much.
Kindly take back the compilation. Yes.
I think what,
They to this.
wait with your I think what 30 supplementary list.
Yes.
This matter I have to file a affidavit in reply. The file affidavit filed by the SRO file. So Rosimi matter we adjourned for 2 weeks. I've taken.
Okay. On a request made by Sri R. Barua, learned counsel for the petitioners, matter is adjourned by 2 weeks to enable filing of rejoinder affidavit.
So Rosimi, can you give me a date, my lord, after vacation? Or 23rd or 24th October?
List on 24th of October.
Always.
Yes.
Maybe. I'd like to mention for listing motion matter.
When?
Tomorrow.
Okay.
Same prayer, similar prayer. Similar prayer. Okay.
Lordship, in item number 19 and 20, we are filing the affidavit in opposition. We have already filed. The served copy also can, that may be called for Lordship.
Your Lordship, I'd like to mention an interlocutory application for listing tomorrow, Your Lordship.
I have for?
I have for listing. For
I have
correction, Your Lordship.
correction.
Pleasure, Your Lordship.
May I please, Your Lordship? I beg to mention one petition for motion tomorrow, Lordship.
Motion, all motions allowed for tomorrow.
I beg to mention item number 16, Lordship.
Yes.
My senior, Mr. Hasibur Rahman, is out of station, so kindly list this matter after vacation.
Okay. Item 16.
Yes, yeah.
His name is not there.
Not there, but it's in Bakalat Nama. His senior counsel.
Okay. No, in the cost, cause list is, okay. An adjournment has been sought for on behalf of Sri H. Ramadan, senior counsel for the petitioner. List after the autumn vacation.
Yes, Lordship. No, I beg to mention for listing the petition for motion.
Item 2.
Please, Your Lordship.
Yes.
Order is page my lord, 11 paragraph my lord 12. Direction was to pay the balance amount for pending bill, my lord. Page my lord 12. Last paragraph my lord 12. In a period of 3 months, my lord.
Third, Sri J. Sharma, learned counsel for the petitioner, who by means of this application has alleged willful and deliberate non-compliance of the order dated so-and-so, passed in so-and-so. The learned counsel has also drawn the attention of this court to the representations submitted requesting for compliance para. That notice be issued, no? Returnable 6 weeks, steps by registered posted AD within two days. Within 2 days. Yes.
Apply this.
Lordship, after some time, Lordship.
Yes, what is your case? Why are you seeking time?
Senior is another problem.
Are you there on record or not? What is your name?
Yes, Lordship, on behalf of A. Alim Sheikh.
Hmm? Your name is A. Islam.
Yes.
Heard Sri A. Islam Learned Council appearing on instruction of Sri A. Alim Sheikh
Yes.
for the petitioner, who by means of this, same, huh? Because of the representation of the cover. It is the specific case of the petitioner that despite an interim order dated 3/9/2025 directing maintenance of status quo of the land in question, comma, on 9/9/2025, the petitioners were forcefully evicted from the land in question and their dwelling houses have been demolished. Flat notice, huh? Sim. 6 weeks. Yes.
May it please your lordship.
Yes.
Here I am challenging the proceeding whereby my lord, my GST has been suspended, my lord. But see, what happened is that in 16/5/2025, my lord,
Hmm.
on 16/5/2025, my lord, a so-called was issued to the petitioner
Hmm.
regarding my lord ineligible input tax credit. Petitioner submitted his reply. Thereafter, another so-called was issued for subsequent year, my lord, on 6th day. Petitioner
Mr. Gogoi, you are supposed to have the instructions.
Yes, well, can it be a two, Malad? In page 36, Lordship will kindly see. This
Yes.
is the impugned focus notice. Here we have mentioned the provision of the rules, Malad. But on what ground we have suspended it is not there. Though in the affidavit we have elaborated. Now in the last line it says, Malad, supporting documents attached for the case specified details.
Yes.
That part probably is, if not furnished, Malad, we can furnish it to the petitioner instead of interfering with the Malad so cause.
my lord,
Let it be a two, Malad, if at all inadvertently it has not been furnished. It can be furnished, my lord. Then he can submit an appropriate
it is
reply.
not my case, my lord. My case is that, my lord. Suppose I have claimed something input tax is ineligible. There is a provision under section 74. They have already started proceeding. They can impose tax, whatever they can do, but they cannot stop me from conducting business, my lord. Since, my lord, 23/7/2025, I have not been able to conduct my business. My GST is in suspend. I cannot make purchase. I cannot make sale, my lord. They have and my lord, they
Yes, that part, what do you say?
My lord.
You can proceed, but why do you suspend?
My lord, when, my lord, these discrepancies have been found, on that ground it has been suspended. Now let me see, my lord, whether any document is there to at least substantiate our, my lord.
You can
That
go
could
ahead,
be-
you can go ahead with the proceeding,
My lord,
even if we accept your plea,
Lord sir,
we allow the proceeding to go on.
Lord sir.
Saying that if some documents have not been given, those should be furnished to him. But what about the aspect of suspending the GST?
No, the ground says, my lord, it's rule 21E, person avails ITC in violation of the provision of section 16 of the act or rules made thereunder. And, my lord, so far as 74 is concerned, my lord, it's the.
Okay, we'll come back at 2 o'clock.
At two, my lord, prevalent means, my lord, it has been obtained.
Yes. Yes, madam.
May I please, Your Lordship? Lordship, in this case, we have challenged the impugned order because, Lordship, the impugned order does not even contain any reasons. There is no signature and DIN number is also not there, which is contrary to the provisions of, Lordship, the Supreme Court. which
Yes,
has been
yes,
laid down.
Mr. Gogoi.
Yeah, I have received instruction.
Yes. What does it say?
Instruction says, Your Lordship, a DIN number is not required as per that circular number, latest circular of.
What about signatures? Is the digital signature?
Digital signature is also, my learned friend has mentioned only one page. There is a 4 page. In the last 4 page, it has been clearly mentioned about the digital signature.
No, Your Lordship.
I have received this instruction. It is there, Your Lordship.
The signature is not there.
Signature is 1, 2, 3, 4. In the last 4 part, ending part, there is a putting the signature.
Let us see. Which page? Page, madam?
Lordship, my order is at page 63. Order ends at page 64. So, Lordship, 63, 64 is the order. There is no signature. They may give in DRC 7. That is not order, Lordship. The order is at page 63. 63 and 64 is the order.
66 is the answer, Your Lordship.
67 is DRC 7.
Lordship, 66 is the signature, digitally signature by Tushar per letter.
63, 64. And Lordship, when DIN number is not given, Lordship, even if they have got the instruction, Lordship, the all over the India, Lordship, the judgment which is there, that de novo consideration has to be done by following due process of law, because Supreme Court has also laid down that DIN number is necessary. This is a curable defect which has to be cured by passing the order again. I'm not saying that the order has to be set aside per se, but order has to be, Lordship, remanded back for de novo consideration for DIN number. Lordship, I'll place the judgment.
No,
It says
see, that is a mechanical exercise of putting the DIN number.
DIN number.
Will it require another application of mine? Perhaps not.
Lordship, because of Lordship, because DIN number, Lordship, nowadays has become necessary because 2019 the circular which is there.
No, Madam, you said that is a curable defect. If he says the DIN number can be given for the giving the DIN number, why is the de novo proceeding required?
Lordship, de novo it has to be done because when you generate it, Lordship, it has to be generated at the time of Lordship, when the order is passed, it has to be generated then. It cannot be given thereafter. Lordship, not a curable defect. This is my wrong, this one, but Lordship, de novo it is done, then it can be done again. Lordship, I'll place only one judgment. Lordship, if your Lordship will kindly.
Okay, we'll issue
just-
notice then at this stage. Let us see you file your affidavit.
Lordship, if Lordship permit me, 9/6/2025, that circular, next circular, if Lordship permit me, paragraph 5.
No, you file your affidavit. This
I'll-
you have placed before this court.
Lordship,
File your affidavit.
of course.
Mm. Heard. Miss Anne Haveli, a learned counsel for the petitioner, who is aggrieved by an order dated 10/2/2025 passed by the Assistant Commissioner CGST Guwahati 2 Division for the assessment year 2020-2021. Full stop. Para. When this matter was considered on 17/9/2025, Dr. B.N. Gogoi, the learned standing counsel CGST, was directed to obtain instructions as the grounds of challenge is principally based on the contention that the order does not bear any signature or any DIN number. Full stop, para.
Lordship, no reason also has also been given. No reasons. There is no reason in the order.
It is also submitted that no reasons are assigned in the said order. Para. Dr. Gogoi, the learned standing counsel, has submitted that as per instructions received, there is no requirement to put the DIN number, and the contention regarding non-availability of signature is factually incorrect. Full stop. Para. Let notice be issued. Let three Gogoi, Dr. Gogoi, for one finance. You will take finance? No. Yes.
State finance,
No, not state. Central finance.
yes, CGST. perhaps.
Reassess for CGC for one. And rest, Central Board of Indirect Taxes,
Yes,
Lordship.
2 to 5 is.
Dr. B.N. Gogoi for 225. Extra copies. What kind of interim order are you?
Lordship, only no course eviction, nothing else. Only,
Notice is made returnable. You make a returnable date.
yes, your Lordship.
Returnable on 27th of October. Para, so Miss Haveli of the Learned Council pays for an interim order. Para. Do no blanket interim order. Though this court is not inclined to pass any blanket interim order of stay, comma, it is provided that till the next date fixed, no coercive action be taken against the petitioner. Full stop. The aforesaid interim order, however, would be reconsidered on the returnable date. You file your affidavit.
Lordship.
Much your Lordship.
Isn't it?
Development.
Item 6.
Wait, please, Lordship. In the last occasion, there was supposed to open instructions, my lord.
Lordship, yeah, I have not received any written instruction, but I have received oral instruction. That number of appeals are pending. Probably within month or two, Lordship, has been for now. Hearing already completed. Lord. Hearing of the appeal has already been completed.
When do you expect the appeals to be?
Lordship, this is within a month or 2 months. 2
Huh?
months. 2 months.
2 months.
No, my lord,
The
we can-
accounts are frozen.
Lordship, in the meantime, interim of the Kerala High Court entertains such type of application Lordship, on the same line.
What is the
Lordship, during pendency of the appeal, order of impin order was stayed. And direction was issued to the authority to one of the judgment within 2 months. So this is the problem with the faceless appeals. Lord.
yes?
My lord, my bank account may be defaced. I may be allowed to operate my bank account.
He's fairly his.
My lord, yes, my lord.
Heard 3 R.S. Mishra, Learned Counsel for the petitioner. Also heard 3 S.C. Kyle, Learned Senior Standing Counsel, CGST,
Income tax.
Income Tax Department, as well as 3 M. Sharma, Learned Counsel for this, Ecobank,
Central Bank of India.
Learned Counsel for the respondent number 7, Bank, Dash Central Bank of India. Para, please have your seat. Considering the subject matter involved and as agreed to by the Learned Counsel for the parties, this writ petition is taken up for disposal at the motion stage. Full stop. Suffice it to mention that on the earlier occasion, dated 17/9/2025, when this matter had come up for consideration, comma, this court had granted time to the Learned Standing Counsel, Income Tax Department, to obtain instructions which Sri Kyle, the Learned Standing Counsel, has obtained. Para. The grievance, in short, is with regard to the freezing of the bank account of the petitioner. Full stop. It is contended that the petitioner has preferred 2 appeals which are presently pending consideration before the appellate authority. Full stop. It is also submitted that though 1 appeal was preferred before the action of freezing of the bank account, the other appeal was preferred. Though 1 appeal was preferred after the freezing of the bank account, the other appeal was preferred before the action of freezing of the bank account was taken. Full stop. Para. Sri Mishra, the Learned Counsel, has submitted that before adjudication of the appeal, comma, freezing of the bank account would be wholly unreasonable, as the same has resulted in a halt in the business of the petitioner. Full stop. Para. 3. Kyle, the Learned Senior Standing Counsel, has fairly submitted that in a matter of similar nature, the Honorable Kerala High Court in an order dated 4/3/2024, passed in so and so, WPC so and so, had resolved the issue by directing the appellate authority to dispose of the appeal in accordance with law until such time not to enforce any demands. Full stop, para. Sri Sharma, the learned counsel for the bank, has submitted that they are simply following the instructions of the IT department and does not have a role in the decision-making process. Para. Considering the facts and circumstances, and also the order of the Honorable Kerala High Court, this court is of the opinion that a similar order would serve the interest of justice. Full stop. Accordingly, it is directed that the appeal which are pending before the appellate authority be disposed of expeditiously and preferably within an outer limit of 2 months from today. Full stop. It is also provided that till such appeal is decided in accordance with law, the bank account of the petitioner be defreezed and he be allowed to operate the same. Full stop. The said observation would, however, be subject to the final decisions which may be taken by the authority in the appeal.
Much obliged, sir.
I didn't say that.
Yes.
May it please your lordship. Lordship, the petitioners herein are victims of evictions, your lordship. Your lordship, they have been residing in that village, your lordship. Most of the petitioners were born there. Their grandparents, their fathers lived there. I have annexed some documents.
What is the nature of the land?
Your lordship, now the administration says that it is a forest land.
Forest land.
Forest land. Now, your lordship, the thing is that, your lordship, there are around 50-60 villages in that forest, your lordship. Only 6-7 villages were targeted. If your lordship may move on to page 19, your lordship, subpara 6, subpara 6. Your lordship, it was such selective eviction, your lordship. I have just quoted some examples, your lordship. In one of the villages named in Anandapur, 30 houses belonging to Muslim community were demolished, while 30 adjacent houses belonging to the non-Muslim communities were left untouched. Similarly, in Silonijan, only 33 Muslim.
Yes, Mr. Gogoi.
My
If
lord,
it's a
this is,
forest land,
this is a very
eviction has to be
My
gone.
lord, eviction has been finished. We had concluded eviction. Regma for this forest has been cleared. And that apart, my lord, what my learned friend is stating at paragraph 19 is pointing out. This has to be substantiated by some record because it is a very serious allegation. Mere
No, see, you can simply say that
It's
14
finished, my
14 is
lord.
a positive right, but we are not on that.
My lord,
If we are more interested in clearing the forest land.
my lords, it's
We
clear.
may not accept his argument
My-
that it is target based. We are not on that.
My lord,
If you are having a policy decision to make all forest land encroachment free, you have to take out the decision irrespective of
My
anything.
lord.
Now,
This land is clear, already clear.
Your lordship, my humble submission in this regard is, I am not here that since my house has been evicted, the other house has to be evicted. Since my children has been deprived of education, now they are here and there, that their children.
your eviction has already been done. What
Yes,
do
your
you?
lordship. Now we are living in makeshift tents. We are becoming a burden on our neighbors and relatives, your lordship. Nothing has been done to rehabilitate us. We have been living in that place since 40-50 years. There are documents, your lordship, where your
Okay,
lordship,
we'll issue notice at this stage. What can we do at this
your
stage?
lordship, our stay has been recognized by various executive
Now,
orders.
what do you expect today?
Your lordship, now thing is that your lordship and issue notice, but the latest development is that, your lordship, there are certain activities going on, your lordship, to delete our name from the voter list, your lordship. Now the thing is that, your lordship, in this regard, your lordship,
Yes,
without your
Charlie?
lordship hearing us, your
you
lordship.
take instructions.
Say, I'll open, so this is on mere apprehension, he cannot submit that we are deleting. If a person's name is to be deleted from the electoral roll, due process has to be followed.
Has notice been issued to you?
No, not
without-
yet, your lordship.
if
But
such-
your lordship, there are statements from the head of the government, your lordship, going around, your lordship. So there is serious apprehension, your lordship. We have been,
Due
your lordship,
process has to be followed as
our
per
stay
written
may be,
document.
Our stay may be illegal, your lordship, but our rights to vote, your lordship. I have annexed voter list of 1985.
Well,
Well-
what is your name?
Your lordship, I have said.
I Hussain Learned Counsel for the petitioners who are aggrieved by their eviction from their house and lands. Full stop. It is the case of the petitioners that they are in occupation of such land since a long period of time, and the eviction done in the name of the land being forest land is done selectively. Full stop. The petitioners also apprehend that their names would be deleted from the voters list. Put the para, that notice be issued, returnable by 6 weeks. Chief Secretary and Goswami 1 and 6, 1, 6 and 7. Then Forest D Gogoi 2, 2 and 8.
I am for 3 months.
Borputari, Revenue Department 3,
I am paying for responder 4 and 5 lots.
4 and 5. Let extra copies be served upon the learned counsel for the respondents within 2 days. You come up with instructions.
Your
On
lordship,
both
may
the
I pay
aspects.
for your your lordship, our rations, which we used to get from this shops, your lordship, that has also not been provided to us, your lordship. If we can get those, your lordship, rations, your lordship, it will help us, your lordship. Your lordship, but because your lordship, we are living like a beast, your lordship. Your lordship, our children have been deprived of education, your lordship. Nothing has left, your lordship. Well,
Ration, where have you mentioned ration?
your lordship, this is the recent development. I have only mentioned, your lordship, about rehabilitation, your lordship.
Ration, you have to make a mention. There is no allegation. Then
My
how
lord,
do you-
there has to be clear.
Look into this aspect.
No, my lord, we will definitely come.
Though he may file application, but since he has expressed, look into this aspect.
Definitely, my lord, but where they are residing presently, what is their identification, my lord? These things are absolutely silent, my lord.
Your lordship,
We cannot provide
I've said in my
ration on the-
petitions, your lordship, there are several petitioners that we are living in the house of our relatives. You are living in makeshift tents. Some who can afford are living in rent houses, your lordship. So, your lordship,
Okay, look into this aspect, ration aspect also. You see, these are important aspects. Without pleadings, how do we ask them to show cause?
No.
Notices for show cause. If there are no pleadings, no allegation, on what do they show cause? You make an
Your lordship,
application.
I-
And I am not
Yes.
drawing my lord's attention to the prayer portion, my lord.
We have seen the
Absolutely
prayer.
vague, my lord.
That is it.
Yes.
Yes, next.
I am not obliged.
May it please, your lordship. Lordship, this is a case wherein we had asked for lordship consideration of our. appeal.
Manually instead of electronically.
In fact, my lord, lordship will see, my lord, page 19,
19.
yes. Para 16,
Yes.
immediately after filing of the appeal,
Hmm.
manually on 2/2023,
Hmm.
the department on 12/4/23 informed the petitioner that he will have to file it online.
Yes.
But nothing was done, my lord, till today, and that document has not been annexed. Even then, my lord, in today also, my lord, let them, my lord, file it, my lord, online. The limitation part will not be considered, my lord. That's
Do it online, okay.
Yes.
because of some
We have
technical
paid the-
glitch, they should not, my lord, file.
Okay.
Because we have paid the entire amount. Lordship.
Heard, Miss Anne Haveli, learned counsel for the petitioner. Also heard Sri B. Gogoi, learned standing counsel, finance, within bracket taxation department, government of Assam. Full stop, para. Considering the facts and circumstances and as agreed to by the learned counsel for the parties, this writ petition is taken up for disposal at the motion stage. Full stop. Suffice it to mention that on the previous occasion, i.e., that is 29/9/2025, the learned standing counsel was granted time to obtain instructions which Sri Gogoi has submitted to have obtained. Para. The grievance of the petitioner is against an order dated 1/7/2025 passed by the respondent number 4 dash Joint Commissioner of State Tax within bracket appeals. Full stop. It is submitted that the primary reason of dismissal of the appeal was that it was filed manually instead of electronically. Full stop. 3, Ms. Havelia, the learned counsel has submitted that such mechanical approach is against the mandate of law and would cause legal prejudice to the petitioner. Para? 3,
Rule 108 maybe, my lord.
3,
It is to be.
Gogoi, the learned standing counsel, has however submitted that that the current requirement is to file appeals online.
It
which-
is electronically.
Online.
Yeah.
Online, within bracket, electronically. And that is in consonance with the prevailing norms, full stop. He has also submitted that the aforesaid fact was not only known to the petitioner, but was also reminded that the appeal should be preferred electronically, which has not been done, full stop. He has further submitted on instructions that even if that if a direction, that even if the petitioner files such an appeal electronically, the same would be considered on its own merits, despite the order dated 1/7/2025, and the aspect of limitation would also be can also be condoned. Para? Ms. Havelia, the learned counsel for the petitioner, has submitted that in view of such undertaking, the petitioner would file the appeal electronically. Full stop. How?
Within a period of 1 month.
Not 1 month,
Let it be 2 weeks,
2 weeks.
considering.
Because of holidays only, I was saying. Otherwise, Lordship,
Holiday, what holidays? Holidays, how many days holidays?
3 weeks, Lordship.
We will give a date then. In view of the aforesaid facts and circumstances and the broad consensus arrived at, the present writ petition is allowed by permitting the petitioner to file the appeal before the appellate authority, namely the Joint Commissioner of State Tax within bracket appeals, Guwahati, on or before seventeenth of October 2025. Full stop. If the same is done within the date fixed, the appeal is directed to be considered on its own merits and without going into the aspect of limitation. Full stop. It is also clarified that the earlier order dated 1/7/2025 shall not come into the way in deciding the appeal, which has to be done on its own merits. Writ petition stands allowed in the manner indicated above.
Lordship will say oral instruction, my lord. I
Oral.
got that, because yesterday was a local holiday, I got the oral.
Oral instructions will come.
I was better.
Much obliged.
Oral instruction.
Nine, my lord, I have instructions. The Schedule B plot of land claimed by the petitioner is a forest land, my lord. We have notified it in the year 1982. Following the process of AFR 1991, also we have mentioned the geo coordinates.
Yes.
Yes, that's. And everything was done based on a report given by the Director of Land Survey Assam.
My lord, please to page page number 41, my lord.
Okay.
Yes.
There is in 1964, it was allotted to us by the government, my lords. After, if the land has been acquired by that's the reserve forest, there should be some process by acquisitions, whether they have acquired from us. From 1957, it was allotted
Schedule
to
B as
us.
a patta land.
Patta land, my lords, the non-patta land, my lords. So we are occupying its, there is the records, it says that since 1957, so we are occupying it important.
My
Is
lord,
it
in the-
Patta land?
My lord, no, my lord, these are second, my lord, kindly turn to the second half of the other part of my instruction. 1972, my lords, the notification under section 1891 regulations were given. Everything was called for, objections were called for, objections done, everybody was heard. After then it was notified, my lords. In 1972.
When did you purchase this land or did you,
It is this is allotted to us by government, my lord.
when?
In 1957, my lords. Please,
There was a
57.
settlement officer appointed, there was a settlement officer appointed, everything was followed, my lords.
lords.
Let us see the allotment order.
Page number 28. 28.
Yes.
There is the remarks 10. In the Assamese portions, I am reading in the page number 30. Lords. মেয়াদি 5-1 নম্বর দরখাস্তর উপপ্রতি মহাকর্তা মহোদয়ের 18/7/85 ইংরাজি তারিখৰ হুকুম মতে 7 নম্বৰ চালান যোগে 121 টকা প্ৰিমিয়াম আদায় ক্ৰমে 120 নম্বৰ দাগে ক অংশ 21 বিঘা জমি 16 নম্বৰ ম্যাদী পাট্টাত 1398 চনত চনত ম্যাদী পাট্টাভুক্ত কৰা হয় 28/11/85
1393.
maybe so.
85.
85. In 85.
You said 57.
No, this is what that is the another Jamamudi one. This is the Trafsita. Trafsita, one.
Let us see your allotment.
This is the UNR record.
No, this is not the record. This is the Jamabandi.
This is UNR, page number 10. Be please prepare.
10.
10. লাট মণ্ডলৰ তদন্তৰ প্ৰতিবেদনৰ ভিত্তিত
10.
sorry 35 my lord
35.
5 annexure B লাট মণ্ডলৰ তদন্তৰ প্ৰতিবেদনৰ ভিতৰত
We want to see the allotment, Mr. Sikdar.
my lord.
Allotment, settlement, whatever.
This is UNR, the record UNR. This is the merely, it was allotted by after.
Those are not land records. Don't
Land
forget the
records.
basics of land law. Jamabandi is not a land record. Where is the records of rights? Give the title. Where do you get the title from? Settlement order, allotment order, patta, whatever. You show us.
This UNR, relevant portion, page number 28, you be close to it. So
28.
28, patta number 16.
Show us the patta. We want to see the patta. That's all. Or the settlement. How do you become an owner of land?
Was the
You don't become an owner because your name is in the Jamabandi or mutation.
paying the premium, my lord. It was allotted to us.
Let us see the allotment order. That is what we are asking you.
Was UNR 18 and 1985. It was allotted to us. So the long.
You said 57 and
No, no,
1980
this
it was
is
allotted.
UNR.
1980 it was always already notified as forest land.
Before creation of forest land, it was allotted to us.
You said 87.
No, there is UNR. I'm saying.
You produced the allotment order.
This is 1957-64. This is the UNR. Gawer Zomamondi Nokol.
Where?
This
Page?
is Page number 41.
41.
41.
Yes, let us see.
1957-64 চনত পানবাৰী মৌজাৰ আউপৰ টেপেচিয়া ননকে গাঁৱৰ জমামন্দিৰ নকল। This is পুৰণিটো নতুন 120 শ্ৰেণী ফ্ৰী মাটিকালি কি হ'ল? This is yours. This is Mahendra Das, the Mohan Chandra Das. These are predecessors.
What is this document? What is the page 41 document?
41 is the 1957-60 চনৰ জন্য পানবাৰী মৌজাৰ ওপৰ
Of the
টেপেচিয়া
year
ননকে গাঁৱৰ জমামন্দিৰ নকল।
1957-68. What is this?
1957-64 settlement, Your Honor.
64, 60.
1957-64 settlement. It was issued by the UNR Deputy Commissioner. This is the certified copy, UNR.
Yeah, what do you say on this, Mr. Gogol?
My lord, apparently the page he is harping on, my lord, is of 64. My lord, I have the communication revealed that we have issued the notification, we have issued the preliminary notification, we have called for objection as back as 1972, my lords. After that, the right of extinguished, my lords. Admittedly, we have also mentioned the longitude, latitude. We are even ready to bring out the map,
Okay, you file your affidavit.
my lords.
My lords.
Heard 3 6 learned counsel for the petitioner. Who is aggrieved by the apprehended eviction from plots of land described in Schedule A
Schedule.
and Schedule B of this petition. Full stop. It is contended that such lands were allotted to the predecessor of the petitioner in the year 1957, whereafter the petitioner is in continuous possession thereof. Full stop, para.
Schedule bill on my lords. And it-
Oh, you're okay. Eviction of Schedule B, huh? Schedule B land, B beautiful. Pursuant to the order dated 19/9/2025, passed by this court, Sri D. Gogoi, Learned Standing Counsel, Forest Department has obtained written instructions dated 22/9/2025, as per which the Schedule B land was notified as forest land in the year 1972.
No, my lords, 82.
1982. And such notification was preceded by the due process of law and by calling for objections from all concerned. Para. Let notice be issued. Returnable by 6 weeks. Home Department. And Goswami 1, 1 4
Opening
5
5,
1 4 5 7
8,
8
8, 9,
9
10,
10
10.
10. Then PR Mohanto, Miss PR Mohanto for 2. And Forest for 3.
3, 6,
3 6
11.
3 6 11. Extra copies. Then steps for service of notice upon responsible 12 to 17.
7.
Why have you made them parties by name?
Lords, they are involved in the Schedule A plot of land, my lords.
They are?
They are related in Schedule A plot of land, my lords. I
are not-
have them private respondents, my lord.
There are 2 plots of land involved, my lords. Schedule B, he says we are evicting him. Schedule A, he says the DC, SP, and then some private respondents have
Lord.
connived and evicted him, trying to grab his land.
Then first you can file an application under the Land Grabbing Act.
No, my lords. Police detaining acts inside the police stations, my lords. The police allowed these persons to encroach into my plots of lands,
No, no,
demolition
no,
my
no,
house,
Schedule B too.
structure, in everything is there, my lords. So there is the grievances of fundamental,
The Schedule A property has been demolished.
demolished, my lord. Within 2 hours, they have done it. And in this time, the police kept us from the place of occurrence and they have detained us in the police
Schedule
station.
B.
This is the very.
Now Schedule A land is under whose occupation?
Now, but this is some land mafia along with the.
Who is under possession?
This is the UNR's, this is from.
You are not in possession.
Now I have to dispose everything. Their Pakka structure was there.
who is in possession?
Now they are the private respondents. You are.
অলপ ওপৰত বেলেগ হ'ব। ওপৰত লিখিব না। So far as Schedule A land is concerned, comma, it is the case of the petitioner that he has been forcefully dispossessed by the private respondents in connivance with the local authorities.
The local.
And B, who is in possession of B?
Now this is the, my lords, the 12 foods, the
No, Schedule B to kind of the schedule.
the schedule B is the on.
Forest funds.
The forest, no, I am in position, but that they have the demolished the structure. I am in position, my lord, till now.
So far as Schedule B land is concerned, comma, it is submitted that the forest department has demolished the structures. Full stop. বাকি হেনে নালাগে, হ্যাঁ? Issue notice. I will to issue notice of respondents by 2 serves by 2 days, huh? What kind of interim order are you expecting?
My lords, the status quo, my lords, be maintained, my lords, till now. Otherwise, my lords, status quo, my lords, it will be the best.
Yes, Mr. Gogoi?
My lord, the instructions indicate that Schedule B is already under position of Forest Department.
Okay, sorry, the Learned Counsel for the petitioner raised for an interim order, para, considering the facts and circumstances, comma, status quo, as on today,
My lords.
be maintained with respect to the land in question.
My-
ওপৰখিনি অলপ বেলেগ হ'ব, হা? পিছত লিখা খিনি হ'ব 2 plots of land, এইখিনিত evict হৈ গ'ল, এইখিনিত evict হৈ গ'ল। এইখিনি মই চাই দিম, মনত থাকিব। Yes, next. Yes, Mr. Andy?
Well, there's a small issue of law that I would like to bring to your kind notice, my lord, which might convince my lord to strike down the entire elections that are scheduled to take place on the 28th. If my lord peruses page 96, my lord.
Yes, your.
Yes, your lordship directly obtained the instruction. It was listed day before yesterday. Yesterday, my lord was
Can I have it tomorrow?
My lord, there's a small.
Just a minute, just a
on
minute.
Friday, my lord.
Friday will be in a hurry, okay. Friday?
I'll not be there in station, my lord. It's a very pertinent issue that I would like to bring to your kind notice, which might convince my lord to strike down the entire elections. Page 96, my lord, is the election notice that has been issued by the president and the secretary, who are themselves candidates in the upcoming elections. As per section 41 read with rule 3 of the election rules, my lord.
Yes.
Section 41 of the Act, read with Rule 3 of the rules, have not empowered the president or the secretary of the society to notify the date or time of the elections. That power has been solely vested in the registrar as well as the returning officer, my lord. When the law prescribes something to be done in a particular mode
Oh,
of
which
management-
page?
Page 96 is the election notice. The election agenda has been set by the president and the secretary, my lord, Indra Mohan and Jaidev Das. Last page of my writ petition, my lord. Right at the root of the election process, my lord.
This is a notice for what?
For holding the elections for the board of directors, my lord, for the tenure 2025, 2025
Okay.
till 2030.
Why is it bad in law?
My lord, bad in law, if my lord now peruses section 41 of the Act of 2007, Assam Cooperative Act
Yes.
2007,
41.
read with rule 3B and 3D, my lord. Rule 3 talks about conduct of election to board of directors of cooperative society. 3B, my lord.
3D.
3B, my lord, B for Bombay.
Yes.
3B, my lord, it empowers the registrar. It empowers the registrar, my lord, to declare the date on which the elections will take place. That power has only been given to the registrar of the cooperative societies. PD and PD empowers the returning officer to notify the time of voting of elections.
Yes, what do you say,
The
Mr.?
powers have been usurped by the president and the secretary in this case.
No, no, in fact, the election authority will be, my lord, appointed person to the notice. Because your lordship is aware that the date is fixed by the board in a board meeting. And that is notified, my lord. This is a notice, my lord.
No, my lord, this is the election.
This is a notice. And pursuant to this notice, my lord, the department will appoint the election, my lord, officer, returning officer. And the returning officer will accept the nomination papers.
My lord, in the first.
This is, my lord.
Just a minute, just a minute.
Yes.
The election of a cooperative society for constitution of so-and-so is fallen under or in a special meeting on such as may be notified by the, but he has already given the date of the election.
Yes, my lord. Date and venue also. Venue is
Yes.
Matgaon community hall.
How
They
do
can't
you
do it.
Date has to be fixed, my lord.
Now, by whom?
By my lord, it is taken by the board. Decision is taken by the board.
No,
Because-
board will take a decision to have an election.
Yes, yes.
Now, the notice has to come from the registrar.
My lord.
Notice regarding the election date, venue has to come from the registrar.
They put the cart
No,
before
no.
the horse, my lord.
Just a minute, sir.
Yes. My lord will see, if we read 41(2),
Yes,
because it is the board of directors, my lord, which, my lord, the duty is casted on the board of directors
yes,
to hold the election,
yes.
so that, my lord, before the expiry of the term, the new board, my lord, assumes the office.
Okay, where is the duty cast?
41(2).
Yes, please read.
Yes, the election of directors of a board shall be conducted before the expiry of the term of the board, so as to ensure that the newly
Yes.
elected members of the board assume office immediately on the expiry of the office of the members of the outgoing board.
Yes.
Now your lordship will see there is a consequence of 41(2) if it is not complied with. Because on failure to comply 41(2), the, my lord, consequence is dissolution of the board. So therefore, my lord, it is the duty of the board to fix the date before expiry of the board for conducting of the election. And this is the procedure, my lord, which is, my lord, followed in each and every cooperative society. Thereafter, my lord, once, my lord, the date is fixed in the board meeting, thereafter the notice comes into play, man. The notice is issued.
No, but here, the notice, it is not an intimation to the registrar. Even if you assume that the venue is notified, date
Yes.
is notified, is maybe within the powers of the board.
Yes.
It has to be in the form of communication, that this we are proposing this date and venue, kindly issue a notice.
Notified by the registrar also, my lord.
This appears to be a notice
Needs to be struck down. my lord.
simpliciter. Cannot be.
Held in the meeting.
Now, what is the difficulty? Have it by the registrar?
No, my lord, this is the, my lord, procedure which is followed in all the cooperative societies.
Incompetent authorities, my lord, the competent authority is
Then
registrar
I-
plus
then
the
the
returning
exception.
officer. The president has usurped the powers of the registrar, my lord. And it has not been ratified by the registrar also.
Now, Mr. Talukdar,
My lord.
this is a notice simpliciter. It's not even a communication to the registrar or any officer in his
It's
office.
in rem, my lord.
Yes.
Mr. Vandik, please have your patience. You are interacting with the standing council. Are we interacting with you? Then why are you disturbing the court's proceeding? You speak when we ask you to speak. We have understood your case. There is no further requirement of any explanation. Have some patience, young counsel. Don't be in a hurry. Have your seat. Have your seat. Yes, Mr. Talukdar.
Yes, my lord, I have an answer to this. Because, my lord, the register, my lord, expression register / election authority,
Yes.
my lord, in fact, the resolutions which are adopted in the board meeting, those are sent to the, my lord, ARCS, Assistant Register of Cooperative Societies. And after the approval, my lord, these notices are issued. So therefore, the ratification is always there.
No, it's not a kind of resolution. It is a notice at page 96.
Yes.
Notice per se to hold an election. Whether the president and the secretary are vested with the powers.
Yes, my lord, what I'm trying to say.
Now, this is what is the date of this? It is 11/9/2025.
Yes.
What has happened thereafter?
No, your lordship will see.
What was the date fixed?
My lord, what I'm trying to say, this notice, my lord, has to be preceded by a board resolution. Board of Directors resolution that we are going to hold this meeting on
Yes,
such and
yes,
such
okay,
date.
okay.
And that resolution, my lord, will be invariably, my lord, sent to the registrar,
Yes.
Assistant Registrar of Cooperative
Yes.
Society. And after the approval is received,
Yes,
then that is amounting to comply with, my lord, 3B.
yes. Now, where is the notice by the registrar?
No, my lord, here the writ petitioner has not annexed anything.
Yes.
We have to go by the resolution. What was the resolution? And thereafter, whether
No,
or not.
let us presume that what you have said, let us accept it.
Yes.
Let us presume that this notice is preceded by a resolution to hold an election.
Yes.
Now, after the resolution is taken, sent for approval,
Yes.
the registrars will come into, his
Yes.
function will come into play.
Yes.
A notice is to be issued by him.
No, notice is not necessarily, my lord, required to be issued because your lordship will see.
Then how do you hold an election?
No, my lord, the approval is granted.
Yes.
Approval is granted by the ARCS that you hold the election.
Yes.
And subsequent thereto, this notice is issued, my lord. It is, my lord, issued by the secretary as well as, my lord, the board of
But,
directors.
the-
In each and every case.
Act says something else.
No, it does not say like that, my lord, because it says the on such that as may be notified by the Register of Cooperative Societies Assam/Election Authority.
Yes.
Now, my lord, once it is approved by the ARCS, that is amounting to notify by him, my lord.
No, no.
If there is a
No.
no, my lord,
No, no,
because you're
you cannot extend to that. Approval is not a notification.
correct, my lord. But what I'm trying to
Now,
say,
what is the difficulty in having the notification done by the registrar or his, as per
my
the
lord,
law?
that can be done. What I'm on, my lord, if it does not vitiate, my lord, it does not go to the root of the matter. Once, my lord, the election notice is notified, your lordship may not interfere, my lord,
No,
because it is not
no.
going to prejudice anybody.
Will not interfere if the election is notified in the due process of law.
Yes.
If it is not done by the due process of law,
Now, if your lordship finds
Yes.
that this notice is absolutely without jurisdiction,
Yes.
then your lordship will definitely, my lord, interfere with the same.
you can still have a clarification that
Yes.
after this notice,
Yes.
you have given another notice, till we are apprised of such notice by the registrar, by the competent authority. You cannot go ahead on the strength of this.
My lord, I don't get it, my lord.
What is the date notified by this notice?
This is, my lord, 1911/9 notice. The date is, my lord, 28/9.
28/9.
Night, yes, on Sunday, next Sunday.
Okay, can you have instructions by tomorrow that any further notices issued by the registrar?
Yes, I can have it, my lord.
Have a telephonic instruction?
Yes, I can have it.
Have a telephonic instruction?
Yes,
Because we need substantial compliance.
my lord.
As well as the mandate which has been laid down in the rules and the act.
My lord.
Rules and the act notifies a particular authority.
My lord.
They gives power to a particular authority to give a notice for election.
Yes.
If you say that this was in terms of a resolution followed by a formal notice, you may not require any interference.
My lord.
Have it tomorrow.
My lord.
Tomorrow?
Well, there's a small issue. I'll be leaving Guwahati, my lord, due to certain.
Tomorrow have some friends of yours.
Well, I'm the only one in this matter alone, my lord. Maybe fix at 2:30, my lord.
2:30
Telephonic
or not,
instructions.
we can accommodate you, but we will not know whether it is possible. Have a colleague of yours. We'll accommodate
Will
tomorrow.
not be able
Okay.
to argue, my lord.
We have heard you. We have taken your point. Your point has been noted. You have a colleague of yours to be there. Okay. Heard Sri Henrik, the learned counsel for the petitioner whose primary grievance is against a notice dated 11/9/2025, whereby the elections, the AGM class elections for the Bodgaon Namapara Main Samabai Samiti Limited has been fixed on
28/9, my lord.
28/9/2025 at 10 AM at the committee hall. Full stop. It is contended inter alia that the powers to notify such elections, well, AGM, an election is vested with the,
Registrar as well as the returning officer.
which rule
3B and 3D, my lord.
is vested with the registrar and returning officer as per rule 3 within the bracket B and 3D of the Assam Cooperative Societies Election Rules 2019. Para 3 Talukdar, the Learned Standing Council of the department has however submitted that the notice which has been impugned clearly appears to be preceded by a resolution of the society. And once such resolution is approved, the requirement of issuing notice stands substantially complied with.
And your lordship will also say, my lord, whether the returning officer had subsequently issued or not, on that count, I
Yes.
don't have any instruction.
He has also further, it however does not, the Learned Standing Council is however not equipped with any further instructions as to whether, any instruction as to whether any further notice
Yes.
has been issued by the registrar oblique
Returning
returning
officer, my lord.
First para. To resolve the issue, the consideration of this matter is deferred till Friday, since tomorrow also is not there, on Friday. Depending on the instructions received, appropriate orders will be passed.
Well, problem.
Friday will not have much matters. This will be one of
Yes,
the matters.
correct.
Problem.
Problem.
Mr. Rachori for whom?
The society. I'm from the society.
Lordship is recorded on the earlier occasion.
Okay,
From
society.
the society. My argument is that they are the directors, board. How they are aggrieved by the inclusion of the new members.
No, no, we are not on that. We are on the aspect of who calls for the meeting.
My lord, that is not part of the pleadings, my lord. The argument
There
which
is
is
no
now
Law, my lord.
advanced.
Question of law.
Their case was totally different, my lord. Their
was
case was the inclusion, they are agreed by the inclusion of the private respondent.
They went for an appeal against that order. They came for a quashing over here.
Today's argument
This
is,
is
my
not
lord,
a pleaded
no,
case.
no, this
No, my lord.
dehots the pleading, my
My
lord.
lord, in the prayer, I have prayed for the quashing of the election notice.
On the
dated
basis of
11/9.
reference.
This is a question of law that I have raised here, my lord, because issue has also not
Question
been.
of law you can raise, but there has to be some foundation.
No, absolutely not.
Because, my lord, first of all, I require on Thursday at interim stay, my lord, because the elections are scheduled to take place on the.
How they are
28th.
affected, Mala? How they are affected? They
I'm
are the
listening.
board. They want, Mala, the whole agenda is they are.
Okay, day after tomorrow.
The president has
Bless.
conceded jurisdiction.
Day after tomorrow. If this point was available, Mr. Handy, you should have taken up this point. This is the first point. We will not be bothered with whether he may have a point, how he prejudiced. Yes, Friday. Yes.
So in this matter, lordship, a demarcation process was initiated by the circle officer Hing, Naga lordship, whereby the whole demarcation process was initiated in a manner that the Palisotro bi-weekly market, in the Palisotro bi-weekly market, the majority portion of the market has been left out of the demarcated area, lordship. And subsequently, a notice was issued by the circle officer to vacate the land by the shopkeepers that they are already there since very long. And no name has been included in the notice. That notice is in page number.
What right do you have on the plot of
Lordship,
land? What
we
is
are
your
the-
right?
We are the petitioners hearing are the shopkeepers who has been doing their businesses in that plot.
Under what right?
Since very long. Lordship, they have been paying taxes, tolls, lordship, in the existing lessees, lordship.
How are you allotted the land?
Lordship, Anchalik Panchayat, lordship, they have been taking taxes, lordship.
Taking
And now-
taxes is not the question. Question is, how are you allotted?
Lordship,
Who gave you permission to have the shops?
Lordship, if your lordship.
What kind of land is this?
They used by Annexure 1, lordship.
Page?
Is the RTI report.
Yes.
Annexure 1, lordship, page number 30, lordship, if your lordship sees. It has been stated that 15 acres of land in the name of bi-weekly market has been allotted, lordship. In that regard only, that lordship, they have been established their shops, lordship.
On the basis of what?
Lordship, the market committee has decided, lordship, that.
Let us,
this-
please kindly show us the document.
Lordship, our limited prayer is. that
See, you have
if-
come to a court of equity. First, you have to establish your bona fide, your right.
Yes, Lord, but
What is your right?
Another moreover, Lordship, there is another aspect, Lordship.
Not moreover, not
uh,
moreover. The
yes,
basic
Lord.
question you have to answer.
Yes, Lord.
What is your right?
Petition number
Don't
2
go
and
to
3,
ancillary
Lordship.
issues.
The petitioner number 2 and 3.
Yes.
They are the intending settler in the market, in the tender process that has been initiated to settle the market loss. These people has been contending in the tender process, which has been shown that this is the bioclaim market, Balajatra bioclaim market. Later on, a eviction notice or a demarcation process has been initiated. Lordship, if the demarcation or the eviction process has been initiated and most of the majority of the markets has been left out, the whole existence of the market changes. And the value that has been given in the market settlement, Lordship, that also changes, Lordship.
Are you aggrieved by the market or what?
Yes, Lordship, if the demarcation and the evictions has been carried out.
Yes.
And it's done, then the intending bidder who has been given bank draft, who has submitted bank drafts in respect to the settlement, Lordship, they will be aggrieved. Because if the structure of the market changes, they won't be able to regain the taxes from the shopkeepers. That is their, that is one aspect, Lordship. Moreover, Lordship,
Those
the
will be
shopkeeper-
considered if the area is lessened. If the area reduces, they will consider proportionate reduction.
the where the demarcation has been carried out, Lordship, if your Lordship sees there is a map, Lordship, in Annexure 4, Lordship, for Lordship, please. The demarcation has been carried out vertically, Lordship. Whether it has should have been done horizontally, Lordship. If horizontally it was to be done, Lordship, the whole market was under the 15 because that has been allotted.
Where
to
is the tender notice?
tender notice is in
Close.
37 page number,
37.
37.
Yes.
In this, in respect to this notice, Lordship, the petitioner number 2 and 3 have already submitted their bank drafts, Lord.
Who are the other petitioners?
The other petitioners are the shopkeepers, Lordship.
So you can have a cause of action for 2 and 3 on this issue. How many petitioners are there? Sixteen petitioners.
Yes, Lord.
What about those?
Some of the petitioners are the shopkeepers, Lordship.
What is their cause of action? Is it the identical cause of action?
Lordship, they have already submitted their representations also, Lordship.
Is it the identical cause of action?
No, Lordship.
Then how do you join the cause of action? 2 and 3 may have a separate cause of action.
Lordship, my senior.
Mr. Sharma?
Lordship, the issue is, this is a market that is allotted to the Anchalik Panchayat. Now, the Anchalik Panchayat, to run the market, they collect tolls. So therefore, their source of revenue are these shops that they have established. Now, we are people who are running our business from these shops by paying tolls. Now, the tolls are paid to the lessees. This is how the entire arrangement is. So these shops are otherwise belonging to the Anchalik Panchayat. Patadama Anchalik Panchayat is the concerned Anchalik Panchayat. And we are doing our business, we are earning our livelihood out of these shops. Now, what has happened here is that
What about 2 and 3?
2 and 3, that their positions will change as of now, because yesterday settlement has been made. Just now I have received a WhatsApp report. They were lessees. I mean, they are intending tenderers who have submitted their tenders, and they are expecting to get that lease. Now, yesterday there has been a settlement been made. I am yet to just open, in fact, that I've just received a phone call. So, in fact, petitioner number 2 and 3, probably whether if they have got the settlement, well and good. Someone will get it. Otherwise, for the shopkeepers, the locus stands because their livelihood depends from these shops. So, this is a common cause of action. What has happened herein is, because of the demarcation been done in a wrong manner, which is my challenge herein, the entire shops or the entire market area has now fallen out of this purported demarcation that they have done. You have seen that annexure.
No, as a shopkeeper, what is your prejudice? What loss do you suffer?
My source of livelihood is these shops.
Yes.
and I'm earning my revenue out of these shops,
Yes,
and I am paying tolls to the panchayat department.
yes. Now,
So now if this particular demarcation takes place, the demarcation is allowed, then these entire shops, as Lordship has seen from the map,
yes,
falls out of the allotted area, because the allotment which was given way back in 1972 was of 15 bigha.
if it is falls out of the allotment area, where is the question of you requiring to pay any tolls?
Then it becomes illegal encroachment. The issue is, if this particular area is within the jurisdiction of the 15 bigha of land allotted to the Anchalik Panchayat,
Yes,
then our right to business or our right to earning livelihood remains. The Lordship will just come to that map. The issue and the challenge. The Lordship will come to page 43. If a Lordship will first see the impending danger that we have at page 40. Page 40 is 25/7/2025 eviction notice. Page 40.
yes,
The circle officer has issued this on 25/7/2025. It is hereby informed to all the concerned that you have been illegally occupying land of number 3 government grazing land of Balisatra village under Botodrova Muja by constructing shops and houses and by doing cultivation. Accordingly, immediately on receipt this, it is informed that to vacate the said illegal land occupied. Now, this is of 25/7/2025. Now, this is a general notice that was affixed in a conspicuous location. Now, based on this, when the shopkeepers of that area, which otherwise falls within the 15 bigha allotted land of the Balisatra Anchalik Panchayat, they inquired. Then they were given page 43,
yes,
which is, however, subsequent to this notice. The notice is of 25/7, and this demarcation that has taken place is of 7/8/2025. Page 40, and then let's also see page 43. Notice of eviction is of 25/7/2025, and this demarcation, the impugned demarcation which we are challenging, is of 7/8/2025, and therein, if your Lordship will see, the Panchayat department or the Anchalik Panchayat was not a party therein. They were not there at the location when this particular demarcation was taken place, which can be seen from the note itself. The officers who are involved here are people from the revenue department only. Now, Lordship will see how it has been demarcated.
yes,
Now, Lordship has seen this red box in page 43.
read in, maybe in your brief, it is not in the court's brief. We have a black and white copy, but doesn't matter which
But-
one.
Yes, my one is. Lordship, that particular area that has been carved out by that straight lines, that box, you've seen that? If I may just for a moment show this page also.
Yes, this is from there, you can just
No.
show it from there, show it from there, which one?
This box, page
Okay,
43.
Yes. What is there?
This is the demarcation order which was given to us, and this demarcation has taken place on 7/8/2025. Now, this demarcation indicates that the land that they have demarcated to be a land belonging to, now there are two entities there. One is a regulated market under the Assam State Marketing Board, and then there is another market that is under the Panchayat, Balisatra market. Total land is 27 bigha. 15 bigha allotted to the Balisatra weekly market under Botodrova Anchalik Panchayat.
Yes.
And the rest is for the regulated market. Now, they have demarcated it by way of this box, showing that this is the entire 27 bigha of land, which is allotted for both the purposes, the regulated market under the Assam State Marketing Board and the 15 bigha of land for the Balisatra market under the Botodrova Anchalik Panchayat.
The
Now-
regulated market is 27 bighas.
Total 27
Total,
bigha.
okay. Out of this 15 is
15
Botodrova.
is for Botodrova, and the rest would be 13. 13 bigha is for a regulated market.
12.
Sorry, 12 also. And this is how they have demarcated it.
Yes,
Now, if your Lordship will see the map,
yes,
the entire shops, Lordship will see to the right-hand side. Right-hand side beyond the box, This is the entire Balisatra market, which has been there from the 70s. These tin roofs are those old markets, the shopkeepers who are running this market. And there is a PWD road which runs across this.
Yes,
So this is the PWD road.
yes.
Here goes the PWD road. So the markets are always by the adjacent to the roads. So this is the market. Now, because of this demarcation being done in a perpendicular manner, the entire market is now out of the purview. My challenge is that this demarcation has been done without any basis. What previous records were scrutinized by the revenue authorities, whether the panchayat authorities were even also taken into confidence, were they there when this demarcation took place? This entire market has been established for many decades now, and it has been established in a horizontal manner across the PWD road. And the demarcation that they have done, which I have placed as a challenge, is a vertical demarcation, thereby completely excluding the entire market. So now, therefore, we become illegal encroachers.
Now, how do you, what is your submission that the earlier area of the market was within the area which were given to the regulated market as well as the biweekly market?
Lordship has seen that the market which has ultimately been established is in a parallel to the PWD road. It's in a horizontal manner. The map itself would show. And this area, Lordship has seen, is a vacant area. The area which has been enclosed by that box, by that square box, is almost a vacant
No,
area.
we have to see whether this demarcation
So my challenge
is
that-
in consonance to the land records. If the it's consonance,
Exactly.
if you are earlier occupying land which was not within the demarcated area, then that will go.
Exactly. So therefore, I have filed representation saying that this demarcation has been done without keeping the panchayat authorities into confidence, taking the panchayat authorities into confidence. They were not there.
What do you say, Mr. Raghunathan?
The demarcation must have been done where the land was allotted. They must have, as it appears, they must have encroached upon the other side of the land. Because this was the area which were.
That is our concern. Why should you include areas which were not even part of the market? We want to see what was the original
No.
plan.
Demarcation was not according to the market, what the area was covered by the market. What was allotted to the market, that has to be seen.
That is to be seen.
Ma'am.
Madam, Revenue Department.
So what was the basis on which this present demarcation has been done? That is the question also. Because the entire market otherwise was horizontal.
No, the question whether it's horizontal, vertical, perpendicular, we are not on that.
No, why I
We
say-
want to know what was the original plan of allotment of the market
the
and is the demarcation exercise consistent with the original allotment?
Yes.
That is what our
Because-
concern
because the
is.
presumption
Madam,
has-
your officers have not taken panchayat and it's a panchayat market. Huh? No, panchayat was not a party in this demarcation process, but demarcation will be done by the revenue authorities. Why panchayat?
Circle officer, Lordship.
Yes.
Circle
That has
officer.
been done by.
No,
Why
because-
panchayat
because-
is
because
required to be?
Demarcation of whose land? Demarcation of the land allotted to the Vadodara Anchalik Panchayat. Then they are an interested party. The Demarcation Act also, demarcation provision also says.
So whichever is the demarcated area, panchayat will accordingly give allotment.
Yeah, they are from your.
So this land is already demarcated to the Panchayat department. Lordship has seen that.
Which page?
Page number 30.
30.
This is under RTI, which was obtained way back on 5/8/2013.
Hmm.
And this has been issued by the circle officer, Green Revenue Circle. May I just read the law?
Yes.
30. Regarding information sought under the RTI Act, this is to inform you that in respect of the above referred information RTI has been total 302 bighas of land
Yes.
in number 3 grazing reserve. So this is the area concerned.
Yes.
Now therein, if a logic will come to page 31, serial number 3. Total 15 bighas of land in the name of bi-weekly market. This is the market we are concerned. So total 15 bigha land has been allotted to the bi-weekly market. Now bi-weekly market is basically a market of the panchayat. So therefore, the panchayat department or the panchayat authorities at the Anchalik panchayat level should have been there, because these shops have been established by them for years together, for decades together. The presumption has to be
No,
the
Mr.
market.
Sharma will be more interested in page 31, the boundaries. If this 51 boundaries, 51 bighas of land
Yes, Lord.
in the name of bi-weekly, 50 bighas, a bi-weekly market, if the present demarcation is conforming to these boundaries, we will not have a case for
I
interference.
understand, Lordship. So therefore, the earlier trade map that they had when the allotment was done, which is not with us, can be produced before the court. If it is in consonance to what I am stating, that as the panchayat market has been established, then I have
Okay,
a
have
case.
the instructions. We will issue a short notice. Third, Sri A. Sharma, Learned Counsel, for the petitioners who are aggrieved by a demarcation process and demarcation exercise carried out on 7/8/2025 of demarcating the Balisatra
Bi-weekly
market.
market.
Full stop. It is the case of the petitioners who are running shops from the in the allotted market, that by the impugned demarcation which has been done without taking into, without having the panchayat department on board, would affect their rights and interest in as much as the existing Balisatra bi-weekly market clearly appears to be
Falling outside.
in a major part of the existing so-and-so falls outside the newly demarcated area.
Yes.
Full stop. Para. Let notice be issued, returnable on, we give a date on 27th of October 2025. Full stop. Three, PNRD. P Thapa on behalf of S. Dr. 1, 1, 3, 4, 6, and 10.
I'm for 2.
Do you have the return? The revenue 2. BJ. Taluka Edition Sinaga Advocate for on behalf of respondables
8 and 9.
8 and 9. Who else? Extra copies. Registered post, which will Batadava Ansalik Panchayat. Madam, you have taken.
That is government law.
Is there any private respondent?
Private respondent.
No. 5 and 7, I think 5 and 7 you have to take.
5 and 7 I have to take
Yes,
it.
5 and 7, registered post with AD.
So I have an interim prayer also.
Live.
Page 40, that eviction notice of 25/7/2025. There is an impending danger that at any moment these houses will be demolished, because now it falls outside the demarcated area. So no coercive action at least till then, Lordship. Otherwise, these shops will be all closed.
Sri Sharma, the Learned Counsel prays for an interim order, which however has been opposed by the Learned Counsel for the respondents. Para, considering the facts and circumstances, it is directed that till the next returnable date, no coercive action be taken against the petitioners with regard to the land under their possession, presently under their possession.
Where they're running their shops.
The interim order would however be reconsidered on the returnable date.
Yes, Lordship. Obliged, Lordship.
Like you said, you should give a-
The matter is non-personal petition claim for settlement of land. Matters left into non-personal business
Non-consideration of
for settlement of land. Further, the petitioners and ancestor of the petitioners possessing and completed designating land of land from 1930, 1935, 1941. Total measuring is 170 acres.
And
What is the nature of this land?
Golf has land, not.
Huh?
Golf has land.
Not grazing land.
Yes.
Your Gigi Gogoi.
Yes, sir.
Heard through Gigi Gogoi, learned counsel for the petitioners, who by means of this petition has prayed for a direction for consideration of their prayers for settlement of the land which is under their possession, full stop. It is contended that the petitioners who are inhabitants of village Borfolong / Brofolong at Gohpur in the district of Biswanath are occupying the land in question since the time of their predecessors and are having dwelling houses and cultivation. The land has been stated to be government khas land. Para. That notice be issued. Returnable by 6 weeks. Ms. P.R. Mohanto learned Standing Council Revenue for 1. Then BJ Talukdar, edition Senegal 2 and 2 and 3. Extra copies.
Interim maybe. Interim, so there.
Interim.
For which the respondent today tried to evict the petition as well.
Where is the notice?
No notice.
No. Sri Gogoi, the Land Council, pressed for an interim order by submitting that there is an apprehension for evicting the petitioners. Puts the para. After hearing, it is provided that no action for eviction be taken without following the due process of law.
Respondent number 7, who is the Panchayat member, your lordship, is not entitled to remain as the cause of the disqualification as prescribed under section 111 of the Assam.
Who are you?
Lordship.
Who are you?
I am a villager of that village and I also contested the election, lordship.
And lost.
If you contested election, what prevents you from filing an election petition?
This provision, this disqualifications, your lordship, the deputy commissioner is entrusted to give them, your lordship. Therefore, we have made a representation because he has
You are a contesting candidate.
contesting candidates, but then also, your lordship, if this issue is there regarding disqualification, if I
Then where will the election petition go?
election period, if there are other malpractices like lordship, that there is a cheating or there is forgery or that there is ragging, all this type of, they will come, your lordship, within the purview of this election petition.
Not very convincing.
So that is what section 111(2) says that.
This cannot be a ground in the election petition.
No, but
If a person is disqualified, this cannot be a ground in the election petition. It can be.
yes, it can be, your lordship, but what section 111 says that if any disqualification is there, then it should be done as per procedure prescribed by the law. Now, the law section 62 of the Assam Panchayat Constitution rules. So far as this disqualification is concerned, like age, then marriage, then spouse, then children, then education.
So there is a distinction between you and a normal voter. You stand in a different footing. You are a competing candidate who has lost. You have to file an election petition.
Not be, your lordship, because
this issue has cropped up in a number of cases. Who is before this court? If a voter comes, he gives the excuse that I'm a voter, I cannot go for an election
petition.
Now, if you come, you say, no, 62 is there.
yes, because disqualification, lordship, this
We have to take a consistent stand.
these amendments in the year 2023 prescribing this disqualification. Now, lordship, kindly see section 111 for a moment. In this, it is provided that section 111 1 subclause H. If any question arises as to whether
Now you have to answer a question. What prevented you from filing an election petition?
when there is a remedy when the act has provided a remedy that by
Act has provided a remedy by way of an election petition. 129B.
129B is there, your lordship, but section 111 H is very clear.
That is for a voter or any other person who makes a complaint.
Just I'll read for a moment, your lord.
We have read a number of times.
If any question arises as to whether a member of a panchayat body at any level has become subject to any of the disqualification under this section. Now, this educational qualification is under this section.
The question shall be referred for decision of such authority and in such manner as the government may by law provide. Now, pursuant to that section 62 of the Assam Panchayat Constitution rules have been amended, wherein in respect of certain disqualification, it is the deputy commissioner which has been made the competent authority to decide. Now, since the Lordship Deputy Commissioner has been given this, I have filed a representation also before the Deputy Commissioner, Your Lordship. He can look into and take a call, Your Lordship. That is a question of election. He should at least take a Lordship.
Not at your instance. You have to tell us why, what prevented you from taking recourse to election petition? Saying that a remedy elsewhere is there, that is not an answer. Was there any legal prejudice or any bar? Mr. Roy?
Lordship, there it is for the voters. No, he is the candidate 127. Right, somewhere.
127 does not.
129 bar of interference by the court in electoral matters. B, no election to the panchayat shall be called in question.
Heard. 3. M.H. Laskar, Learned Counsel for the petitioner. Full stop. As per the facts projected, the petitioner and the respondent 7 had both contested for the post of member of 4-number ward of Rangauti Gao Panchayat in the district of Hailakandi, in which the respondent 7 had won. The petitioner alleges that the said respondent 7 is disqualified under section 111 within bracket 2 within bracket B of the Assam Panchayat Act 1994, which is in connection of a candidate to be to possess minimum educational qualification of class 10. Full stop. Para. 3. S.S. Roy, the learned State Council has, however, permitted that for a competing candidate, the recourse to challenge the election is by means of an election petition, for which a tribunal has already been constituted. Puts the para, be that as it may, let notice be issued, returnable by 6 weeks. Yes, Ms. Pete Hopper, 1,
3 and 4.
1, 3, and 4 on behalf of S. Doctor. Huh? And S.S. Roy, 2.
2, only 2, Lordship.
And Dubey, is he there in the court?
I've seen.
R. Dubey, then
Sir,
A.B. Castro, he's there, Dubey is
Yes.
there. R. Dubey for
5.
5. Deputy Director of Sanskrit Education, any Standing Council Education Department. Who is there in the court? We record
Lordship. Khatuniar name may be.
NJ Khatonian for 6 extra copies by tomorrow. Steps for service of notice upon respondent 7 by registered post daily. Steps out tomorrow. Maintainability of this writ petition is however kept open. Mr. Bhaskar, if I will say something else. I don't know. Tendency of this writ petition shall not be a bar for consideration and disposal of the representation. If that is done, your problem solved.
Yes, yes. Obliged.
14. Lordship, the matter pertains to Lordship correction of land record, Lordship. Lordship, the fact is that petitioner's father owned and possessed, Lordship, a plot of land, Lordship, but inadvertently, Lordship. Lordship, he died leaving behind, Lordship, 2 sons and 2 daughters, Lordship, but inadvertently, Lordship, Lordship, kindly come to the page number 13, Lordship.
Yes.
Name of one son was recorded in the Jamabandi, Lordship. That was not followed by any mutation order, Lordship. And thereafter, having been aware, Lordship, We, Lordship, submitted application before the circle officer, Lordship.
We means
Lordship, the petitioner and three others, two others, Lordship. And
including the son whose name was recorded.
Lordship,
All four of you.
three of them, Lordship. Lordship, may kindly come to the page number 15. 15, Lordship. Applications converted to miss case. And notice was issued, Lordship, on 22nd March 2025, Lordship. To the petitioners and to the opposite parties, Lordship. Both the petitioners and opposite parties appeared before the authority, Lordship, and the opposite party, Lordship, on that particular day submitted an NOC also, Lordship. If the name of others were inserted, Lordship, he has no objection. But till that, same has not been done, Lordship.
Lordship, wrong file has come to us. Lordship. Notice revoke.
This is only my case, Lordship. Thereafter, Lordship, I submitted another application before the Deputy Commissioner.
When was the last date?
Lordship, no date has been fixed, Lordship.
No, when did you last appear?
Last appear.
NOC was given when?
Lordship, 29 March, Lordship. 29 March.
Yes, you get the instructions.
Lordship, immediately after the open.
Okay.
Third.
Sri H. Talukdar, Learned Counsel for the petitioner, whose grievance is with regard to
Need to wait.
the aspect that no final orders have been passed
Page 4.
in miss case number 176-2024-25, which was instituted for correction of land records. Full stop.
Wrong.
It is submitted that in the said miss case instituted, comma, the respondent number 3 had, who is your brother?
I have not implemented him as respondent, Lordship.
The difficulty.
Lordship, he has submitted already the NOC, Lordship.
It happened here, how do you know? The opposite party had submitted NOC, in spite of which no final orders have been passed. You should have made him a party. How do we decide this? How do you decide this? Mr. Roy,
Lordship, that.
he is not a party. We do not know.
That.
It however appears that the said incumbent has not been made a party respondent in this petition, full stop. With Talukdar Learned Counsel prays for and is granted 2 weeks' time to file appropriate application for implement. Yes. Till the vacation.
Till the vacation.
2 more days.
Madam.
2 more days and then the floodgate will close. Whatever is possible, do within 2 more days. Okay.
Item 22 is similar, madam.
22.
But in
Give a corrected copy.
in 22 Lordship, I have just one point to raise before Lordship. The registration was cancelled in 2020. Lordship.
The
2020.
registration was cancelled.
Lordship.
In the COVID period, madam.
Okay, 22 में leave it. He, however, raises the issue of delay in approaching this court as the registration was cancelled in the year 2020.
Lordship.
तो बाईस में आएगा, हाँ? Fifteen and 22 था वो. 22 में let's this the last one observation. Yes, Mr. Saikya.
Your Lordship, working, my husband working as a senior relationship manager under authority of Bajaj Alliance Life Insurance Company Limited. And during the course of his employment, he died in a road accident arising out of Jalpai police station. Applied on 31st/3/2025. But Lordship, the appointment letter itself annexa in Lordship, that is relevant portion, page number 15. May I please to read? Term life insurance, you will be covered by a life insurance cover for a sum issued as per company policy. This cover.
Your grievance is against whom? Bajaj.
Further Alliance Lordship, but
That too for enforcing a policy.
yes, Lordship,
Not
so
in a
I
red
have
coat.
already approached before the ombudsman, Lordship, but ombudsman has remained silent, therefore I am.
You can challenge the orders of the ombudsman, but how can you come to a writ court?
So
Had it
Lordship,
been some matter of public duty, then matter, this is a private kind of a,
so Lordship, writ will be maintainable only because of that, Lordship, all the financial authority is the parent authority of the Insurance Regulatory Development Authority. So Insurance Regulatory Development Authority, its parent authority is one of the Union of India. That is why I am.
you cannot just go up and up. It's not like that. What kind of duties, what kind of rights are you trying to enforce? It's a private right. It's not nothing to do
Insurance
with.
Regulatory Authority is one of the.
You are not
financial-
aggrieved by, you are not aggrieved by the insurance. Did you are aggrieved by the action of Bajaj?
Yes, you.
And you have not even made the entity a party. This is now not how you present a writ petition. See your array of parties. Where is the entity? Where is Bajaj?
Well, I have made a party.
Where?
I made a party ESIC Employee State Insurance Company.
This is not Bajaj.
And another, the head of the authority.
Head of the authority. What head of the authority?
And,
Head of the authority.
Respondent number 4, that is the.
He's the branch manager.
branch head.
Where is the entity? That company has to be a party here.
I mean,
But you read not, it will not lie. You are unnecessarily wasting your time. You can approach the consumer courts, you can approach the ombudsman, insurance ombudsman.
Ombudsman, I have already been approached.
Where,
But
where,
remain silent.
where?
Your
Page.
lordship.
Page.
Annexer H1, page number 33.
What is the answer?
But answer is that has remained silent, Lord. They have denied to receive the same, stating the reason that whenever we approach, so we did not enclose the insurance policy copy. That is the verbal instruction.
You give the insurance policy copy. Where is the? What are your grievances? What relief are you seeking here?
Another ombudsman annexer H1, page number 33, Lordship. Before the authorities and of the chairman, ombudsman located at Pandadar, Guwahati, Lordship.
This is your prayer is not like that. Your prayer is a different to release the compensation, release the insurance amount. You have not even challenged the action of the ombudsman not taking any call on your petition. That is not your prayer. You are not aggrieved by the inaction of the ombudsman. See your prayers. It will not be maintainable. At least amend the prayer. We may be able to help you. Otherwise,
Your Lordship, I will amend
amend the prayer.
prayer, Lordship, prayer person.
Heard Sri M. Saikia, learned counsel for the petitioner, as well as Sri S.S. Roy, learned CGC. Para? A bare perusal of the subject matter involved would disclose that the dispute is with regard to an insurance claim. Full stop. There is, however, an averment that the petitioner had approached the ombudsman, which, however, has not considered the case of the petitioner. Full stop. As there is no specific prayer with regard to the alleged inaction on the part of the ombudsman, comma, Sri Saikia, the learned counsel prays for and is granted 2 weeks time to file appropriate application. Para, list after the vacation.
Keep your blessing.
Lordship, in this matter, we have filed our affidavit today, Lordship.
Served, copy served upon you?
Yes, Lordship.
Would like to respond to this?
Better may be taken up after vacation.
Okay. Rishi Sharma, Learned Standing Council, NHAC, NCHAC has submitted that affidavit in opposition has been filed today. Full stop. Your name?
IL
I?
on behalf of you.
Please give your name. Sri so-and-so Learned Council appearing on instruction of Sri B. Burwa, Learned Council for the petitioner, prays for and is granted 3 weeks' time to file rejoinder affidavit.
God bless you.
List along with the affidavits.
Look, you have filed our reply. For your direction.
You filed?
It is
Lordship.
pouring into this.
Lordship, we have also filed a affidavit today, Lordship.
So I think everyone will have to see and file.
But the question will arise, how much land does a man need?
That is what we read in the school. There was a story.
How much land does a man need?
I tell that story to many people. Seeing certain actions. He was given, that run as far as you can till sunset. And that will be yours. And he did it. And by the sunset, he collapsed.
He
and-
collapsed.
So.
We know this story.
Yes,
The faster you run, the lesser you'll get.
Ultimately, it is that.
Because you'll get tired more early.
That tiny trick he had it in that. That was a chapter in that book before in school.
Yes, I'd like to exchange further
I
affidavits.
think we have to see and input.
We'll have a date after the vacation.
As after Diwali, that will.
Okay. Heard Sri P.K. Goswami Learned Senior Council, सबका नाम लिख दीजिए, Paris में. Also heard Sri Sri Sharma, Learned Standing Council NCHAC, and Sri S.S. Roy for the state respondents. Para. This court has been apprised that in the meantime, 3 numbers of affidavits have been filed, which are yet to be tagged with the records, and some of which are yet to be tagged with the records. The Learned Council for the parties pray for some time to obtain further instructions and file rejoinder affidavits if so instructed.
So far as NCL, we have filed the affidavit.
We have noted.
Yes.
We'll record your name.
Lordship.
D. Sector, Learned AG, both for the state and the NCH.
NCL.
We give a date.
Lordship.
On request list on can we have it on
It will be in the first week of November, Lordship.
we will have it on 10th or 11th of November.
Lordship. 11th.
11th of November.
That's a Tuesday.
11th of November.
Lordship. Proposal. 11th November.
11 November, is it okay, Mr. Goswami? 11 November. We had put a question to Mr. Goswami. He'll convey it to you.
Lordship. Deeply.
We can put the question to you also. How much land does a man need?
Man need very limited.
No, you think over.
Yes.
It cannot be
A
answered. in
man
one-
is MAN or MEN.
A man, a man, we said. Amen. Amen cannot be MEN.
Now she is saying, what about women?
Man includes women.
We'll find it out, Lord.
Oh, women might need more land. So I'm talking about confining it to a man.
Highly obliged.
Yes.
Still GST is the party line.
Well, my instruction is let it be after the vacation.
Otherwise, covered by lots of problem.
Even then, let it be on the reopening.
If it is covered,
Well,
let it-
I have sent the,
huh?
I have got sought for the inspection, let it be.
What is it? Cancellation?
Yeah.
I say,
Well, just.
consider. Is it there? Consider. It's only a consideration order. When was it cancelled?
Let it be on 13, my lord. He will accommodate, my lord, for 1 day.
Insert my lord, 23, my lord.
No, let the reason be there at least, my lord, why we have cancelled. Because this cannot be a routine manner, then, my lord, now every.
Mr. Kyle, your colleague has said,
Yes, ma'am. Yesterday
tomorrow,
also-
day after tomorrow is the last day. Floodgates are going to be closed. Till day after tomorrow, no objections.
No, let it be on my, not reopening on 13, my lord.
So Friday, it seems the instruction will come from this Guwahati only, man. Come on Friday.
Admission put lower. Let it be on my 13, my lord.
Okay.
13.
Okay, 13th, okay. On the Hertz, we arrest Mishra, Learned Counsel for the petitioner. Para 3 B Gogoi, Learned Standing Counsel, Finance Taxation Department prays for some more accommodation to enable him to obtain the instructions. List on 13, no, not 13, 14th.
Right.
14th.
31 is similar.
Hmm?
31.
31 is similar.
Okay, 31.
Month only.
Yeah. 23, my lord. Earlier, second half, my lord, because my lord. Second half.
Okay, in the second half. But we'll finish this.
My lord.
24.
Lordship here. And last week they have filed affidavit, Lordship. We want to file a reply, Lordship, for last occasion. Here, Lordship, the patta land of the petitioners and the power grid company want to bisect our land without following due process of law, without the acquisition, without paying any compensation. They straightway came to our land to erect the post, and that is why this honorable person interim order, Lordship. And even then, in spite of the operation of the interim order, they tried to evict us from the land. That is our case. So now they have filed an affidavit, respondent number 4. We want to file because of the because Sarvi Sharma was out of station, and he only arrived today, so we could not prepare the affidavit.
But there is no interim order as such without following the due process.
My
of
lord,
law.
exactly that is the scenario.
What is the difficulty?
My lord, what the petitioners are doing, they are interpreting this order, trying to demonstrate that there is a stay, and we are not being able to work. Now, my lord, this is the last leg of the project. Till we do not do the construction, we cannot assess the damage and pay the
No, their
compensation.
interpretation is their interpretation finally.
It's not my lord.
You're the authority. You take a call.
My lord, if my counter affidavits page 165 annexure 16 is seen.
We have to file our reply, Lordship.
No, we are not passing any orders on the counter affidavit. Give you time. But we are saying where is the interim order?
My lord, there is no interim order.
Go ahead. But following the due process of law.
My lord, we are following the due process of law. as and when we do the construction, we will assess the damage and pay compensation.
Yes.
My lord.
Then how that can be after the causing damage, how they will pay? Let them acquire the land as per the process, lordship.
See, we are not modifying the interim order. Whatever is there is there. It was passed when?
My lord, 2023, my lord.
There, it-
It was never listed, my lord.
6 weeks returnable, not listed. Why?
My lord, page 151 of my counter affidavit, the order would be.
It comes after 2 years.
Yes.
Why?
No, no.
Let us see.
My lord, page 151, my lord.
And only last.
149, it starts.
Just a minute.
For this honorable court, and that day I
Close in my court.
My lord, the last paragraph, my lord.
Just a minute, please. Just a minute. Last paragraph of
Page 151, my lord, my counter affidavit,
151.
my lord.
When did you file the counter?
My lord, we filed it last week, my lord. If I may,
151.
my lord, my counter affidavit.
Yes.
Till the next date
Yes,
of-
we have seen this.
My lord,
We have seen this.
my lord. So this is what has been wrongly interpreted when they are saying that there is a stay, and based on this order, my lord, even the authorities on ground, they are feeling their hands are tied, my lord. Accordingly, at page 165 of the same counter affidavit, my lord, annexure 16. If I have, my lord,
165.
165, my lord.
Yes, please.
My lord, the last paragraph of 165,
Hmm.
if I may, my lord.
Hmm.
Additionally,
Yes, we have seen this.
we noted that the Honorable Guwahati High Court. So, my lord, this is becoming an impediment because of the wrong interpretation, and the petitioners also going to the site with the order and saying that there is a stay. Now, my lord, we will not shy away. We will pay the compensation, whatever is due to them.
lordship has reduced the page at 20,623.
Yes, we have seen that. There it was, first, there is no interim order. Number 2, till the next date of listing.
My lord,
Here, lordship, the last paragraph, till next date of listing, the respondent 1 to 4 are hereby directed not to draw high voltage power transmission line over the land of the petitioner. Discussion para 11. That is my case, not to draw the line. That is my case. Let them.
Without following the due process of law, is there a requirement for acquiring land?
They have to pay lordship.
No, payment they'll make.
Tomorrow, somebody will enter in my premise, lordship.
Payment is,
Admittedly, it is
madam, payment is made first or after utilizing the land? Is there a concept of advance payment?
Because only
You
last
file a
week-
reply, we'll clarify this.
My lord,
They have filed.
my lord,
Have there been so?
there is an order of my lord's court, similar issue had come up in Arunachal. If I may, my lord.
No, we're not like to look at any order.
My lord has come down and stated that the compensation will be given in 3 phases. That is, stages are foundation, construction, and stringing. So, my lord, as we do these works, we will assess the damage and pay compensation.
Okay, heard Miss Piece of learned concept for the petitioner. Yes, we record his statement, and you can record, close this.
Lordship, let us have an opportunity to file our counter rejoinder.
My lord, Century Textile also, the apex court is clear that
Also,
they cannot be
and
granted.
learned counsel for the respondent numbers 1 and 2, who has submitted that counter affidavit has been filed on 15/9/2025. Full stop. Miss so T-Sum learned counsel, Miss Sum learned counsel for the petitioner prays for time to file rejoinder affidavit. Para at this stage, Sri Khera, the learned counsel, has submitted that while issuing notice on 27/6/2023, the same was made returnable in 6 weeks, and a conditional interim order was passed in the following manner. Page 151 is till full stop. He submits that the matter was not listed thereafter for a long time, and in spite of the conditional order, comma, it has been construed that there is an absolute bar for proceeding with the work in question. He has emphasized on the importance of the work and has submitted that this is the last phase for completion of the project. Full stop. Considering the same and also having note of the interim order, it is clarified that there is no blanket ban on the project, and the only concern of this court is to ensure that due process of law is followed for drawing the high voltage power transmission line over the land of the petitioners. Full stop. The concern of the court would also be on the aspect as to whether appropriate compensation, adequate compensation is appropriate, adequate, oblique fair is received by the aggrieved parties. So list on, we give a date. How much time, madam? List on, we'll have it on 12th of November. Who is three? Name, three. What is your name? Miss Sida's learned counsel has appeared and has submitted that she has instructions to appear on behalf of the respondent 3 and would file the power shortly. And C does and M does, huh? Okay. Okay. You're for 3 and 5. 3 and 4. 5, 6, and 7 say. We have already granted time. We have said so. We have clarified, Mr. Khera, we are not required to clarify. Still then we have clarified. There is no blanket ban, we have said. Okay. 25. Mr. Otto? You're for whom? Sole respondent. Okay. 3. As Dr. Learned Counsel has submitted, has renewed his prayer and has prayed for further time to file the affidavit in opposition. List on list in the first week of November, by which no, not first week of November. Today is not first week of November. I take one say October, September last. List week in the last week of October, by which time the affidavit in opposition is required to be filed. Yes. Yes, your response? You come because there is an IA where they have alleged that interim order has been violated. Okay. Third 3 FU, Borbia, Learned Counsel for the applicant / writ petitioner. Para 3 SS Roy, Learned State Counsel, prays for and is granted time till 3 weeks time to file affidavit in opposition. List in the last week of October 2025. He'll give. Yes. What is it? There's an interim order. You take care of the interim order. because they have already alleged violation. Take care. Okay, next.
27 and 28.
Yes, we are only in the IA we have filed. Main case, only interim order, if any. Interim order passed earlier to continue till the next date of listing. Yes, it is. We don't have too much matters. We have only one matter, bail matter, and this matter.
But I don't like giving a minimum of 8.53% entitled under the law. But they cannot get a maximum of 20% because it's a loss making guard. So now my submission is that it cannot be given, which is the loss making.
2 o'clock you cannot be here.
Eviction matter is not big much.
Okay.
Limiting adjournment, whatever, what the eviction matter.
Today election matters will not be held. This court can assure you.
Application that has actually become the returning candidate. Matter pertains the owners to discuss.
Last week of the vacation, only 2 days remaining. Okay, Bab, yes, you come. We'll accommodate you. Yes, next.
Item 29.
Yes. Guideline for?
That's why my talk please. In the meantime, provided environment. Now I cannot do my environment.
Yes, who's for the other side? State Bank of India, who is appearing? SBI has their counsel. Why don't you contact Mr. Who appears for SBI? Mr. Roy, normally? As Sri Doctor. And I think Nandi also appears. Huh? K. Das. Can you contact any of the council? Because you have served Dusty. They have been served. So there is no requirement to wait for them. But in the interest of justice, can you contact either Mr. Nandi or Mr. Datta? Get the details from Mr. Roy. Okay? Come in the second half. We'll try to. Which is your matter? To PNB?
Yeah.
Okay. We'll just complete to. Okay. No, we'll accommodate him. No problem. Item number?
The reason for suspension is because petitioner is involved in some of the illegal activity, whereby it has been found that though he has shown that some transactions were there, the actual on verification, they found that there was no transportation. And in order to guard that this because suspending non-different or is proceeding instead of 65 in loss proceeding this and is not never there. Only when difficult option there in the allegation line. Then we should settle for the time.
16.7 has not been brought to a logical conclusion. Now, if one proceeding was already initiated on 16/7/2025, which is yet to be culminate in some order, why have you again proceeded with 23/7?
Section 74 of civil C only when it is found that the petitioner is involved with some criminal activity. 74 comes, otherwise it is 73. It says determination of tax, not paid or short paid or erroneous paid refunded. For interest wrongly available. For implement results of fraud or any misstatement or misstatement of. Under that provision, I have now this I have taken wrong things matter. This is obviously financial time less than 74.
Now, what do you propose, both of you?
This matter. If now, is there, they can proceed matter. If I take it, I can go for appeal. There's problem for appeal. It's in the 74, however, but there is something to show in the act or in the rules that postal proceedings cannot be initiated. Now, obstacles to that, we reply of course, will be satisfied. Because we have to reply to the same in the other proceeding also. And if we can reply, we can see the everything option there, themselves take the potential only. Paragraph, you can see the paragraph.
Where is the suspension order? Let us see the suspension order. Is it 23/36? Yes. Your power to suspend is emanates from which section? Rules. Page 192. Rule 30. What? Rule 21. And where a registered person has a good this shall be deemed to be suspended. 21. Yes. 21A is not by that when a registered person has applied for cancellation. He has not applied for cancellation. Okay, where the proper officer has reasons to believe is liable to be cancelled under 29, section 29 or rule 21. And he may suspend the registration pending the contemplation of proceeding. If the power is there, will not at this present moment will not go into the merits, inter se merits.
Okay, right. They pocket 22 only. Nothing more thing that matter. 21, 21 subsidy they have pocket, and they say you have to reply on this matter.
You're right. Yes.
Nothing on the
What have not done? Just said, my lord, Procedural 21 key avails in the expiry in violation of the provision of section 16 of the Act for the rules to be there. And I can consider it, realize, my lord, therefore, let notify this transactions are fraudulent. That's why I said, my lord, in case 30, the last one, kindly refer the supporting documents attached for case specific details. This is to be provided, but otherwise, of course, you will not be able to reply on the. And one for the photo, second, my lord, why it has been suspended. Where are the supportive documents? They have already communicated to the dispute for this matter. Tomorrow. We'll be interested in two things. We can, thinking aloud. Number one, we are not there is no dispute regarding your power to suspend. 21A2, when you contemplate a cancellation, you can also suspend. Now, we go to his allegation that there is a show cause notice which also contains a clause of suspension, and his allegation, his stand is that the show cause notice has not stated any reasons and rather quoted a part of Rule 21. 21E. 21E. Your response to that is the last line says that there are supportive document. If you can produce any supportive document which were actually given to the petitioner, then it will not be a case of interim order. We will examine the case. We are only on the aspect of interim order tomorrow. Okay. No, judgment will be there if no reasons are disclosed. But if he says that reasons are disclosed, and there is an indication also of the reasons and documents, then we'll say on the request of Sri B. Gogoi Learned Standing Counsel, Finance Taxation Department, consideration of this matter is deferred till tomorrow to enable him to obtain the instructions. Specific instructions are required to be obtained with regard to the last sentence of the impugned order dated 23/7/2025, which refers to supportive document attached for case specific details. The page 36 of Silo, last line for case specific details. We'll have the order during the course of the day. Case do the last. PNB to Cooperative.
27 and 28. This case on behalf of some key corporation limited ACPL. I can feel itself. We are basically saying that an amount is lying with the Assam Employees Provident Fund Organization, which was the result of the option sale proceeds of a particular figure. There are two figures in things. And ACPL was the original owner. They were managing, but because of various issues, we decided to keep it on lease. Then that also failed, and ultimately it was option sale. And the amount which now was obtained from that proceed, the option sale proceed, it is now lying with Assam Employees Provident Fund Organization. I am sure the Punjab National Bank will raise an objection. Last time or last year also during the when we wanted to give the owners, they raise an objection because there is a mortgage of the curtain in favor of the bank. But if we look at the total outstanding amount, it is more than 7 crores, and their outstanding is less than 7, 6.4. So if we give 20% bonus also, the amount will be. If we take the case of both the gardens, if we give.
There are two gardens.
There are two gardens, two items.
Okay, two items.
More than 7 lying with the provident fund organization. If we give 20% for a period, now the period is less, not full year. The period for which the bonus is payable by ACPL is 1/1/2024 to 21 2024, page 15 of the I. And previously, last year also, this honorable court allowed that from the amount, a particular portion is to be released in favor of the employees, the workers of the tea garden during the Durga Puja. So my humble submission is that Lordship, there is no right or no ground obtained by Punjab National Bank in this case. And bonus is payable under the bonus act, which is a statutory provision.
Bonus है कौन सा?
Section 10 of the Payments of Bonus Act 1965.
Section?
10. May I read it?
Just a minute. Yes.
Subject to the other provisions of this act, every employer shall be bound to pay to every employee in respect of the accounting year commencing of any day in the year of 1979 and in respect of every subsequent accounting year, a minimum bonus which shall be 8.33% of the salary or wage earned by the employee during the accounting year or 100 rupees, whichever is higher, whether or not the employer has any allocable surplus in the accounting year, provided that where an employee has not completed 50 days of leave, or those who will get, that is a provided is not completed. And also will also have a look at section 34. Section 34. Effect of laws and agreement inconsistent with the act. Act means the bonus act. Subject to the provisions of section 31A, the provision of this act shall have the effect of withstanding anything inconsistent there which contained in any other law for the time being in force or in terms of the award, agreement, settlement, or contract of services. So, if an objection comes from the Provident Fund also, that they have also entitled to get that the option was done as an initiative of Provident Fund organization. Because there are some statutory dues to them also. So therefore, they were permitted under the Provident Fund Act to go for that option. So now the money is lying with them. So if we give 20%, the total amount will be 72 lakhs, and if we give 8.33, it will be much less. It will be around 30 lakhs. So my humble submission is that the workers should get the 20%, which was earlier decided. Last year also it was 20%, and this year also it will not make any change.
Where is the 20% thing? From where would you get?
The IA will have stated that. There is the 1/3. Paragraph 12, the period. Paragraph 30, the difference order date is submitted as per the payment of bonus act 1965. It is mandatory to pay a minimum of 8.33% to the employees of an organization, even though it is in a loss-making organization. However, during the last 12 years, ACPL has been paying bonus at 20% to its worker and employee from the funding of by government of Assam. Mostly the bonus for the year 2024 is payable in the year 2025. Accordingly, in respect of Rajabari Tea Estate, there is a total bonus liability of 22 lakhs 50,541 on paid wages calculated at 20% due to the workers employees of the Rajabari Tea Estate. However, if the bonus is calculated at 8.50, the amount is 9.40. So this is in respect of one of the guardian. The other the same paragraph. The teaching tea estate case, if it is 20%, the amount will be 49 lakh 83,834. And if it is 8.33, 20,75, 767. Now my humble submission is that we cannot tinker with the 20%. That will, if we reduce it, there will be a huge law and order situation in the tea garden.
So for few lakhs of rupees, we do not want to pay this. Every year that is a big issue. So when it is 20 years, why it is 20% for last 12 years? Because that was settled with the workers.
20% of what?
Paid wages. There's a calculation. The paid wages calculate 20% due to the workers of the year. So 20% of the total wages paid during the whole year.
No, please explain the facts. You are the you are owning the gardens. Two gardens.
There, otherwise, we have about 14 gardens, some T corporation.
No, understood. But here two gardens are involved. Those. Okay.
So as a result, give it on lease to a particular party.
Okay.
That party also failed to run it.
Okay.
Thereafter, this provident fund organization, they are not getting the PF amount.
Okay.
So they have invoked the relevant provisions of the Provident Fund Act to go for e-auction to recover their dues, statutory dues.
E-auction of the market of the garden. Now, who is the owner?
Now, there are from this particular date, now it is managed by a private party who has a successful bidder in the e-auction.
After 24, October 24.
Yes.
No, 1/1/24 to 21/10 is your probably your period. After 21/10/24.
So from 13/8/2024 down.
Now, one is 12/8, the other is probably 21/10/24. We have just noted the date.
Yes.
So maybe after October 24, it is somebody else's headache. You are only for the period one. You are the owner. You owner.
The garden was attached by Provident Fund and it was put to sale to e-auction. Punjab National Bank forwarded some advances. That is why they have a claim of that amount. They also want a claim from that amount. Whether that amount is payable or not payable, not seen. That the final hearing will ultimately give the answer. So now, at this stage, in the interim lordship, last year also identical situation arose. At that point of time also, that order is at page. Page 21 of IA number 3207. Here in paragraph 4, 5, and 6. There it is.
Yes.
It is seen that both are directed against the e-auction sale notice dated 6/6/2024 issued by the Assam Tea Employees Provident Fund Organization to the effect that upon auctioning the tea garden in question, the said respondent should disperse the balance amount of the said proceedings to the petition on the ground that the leasehold rights were mortgaged by the private respondents in favor of the petitioner. Prima facie, upon hearing the learned counsels appearing on behalf of the parties, the court is not satisfied with the case set out, more particularly taking into account the lease deed so executed by and between the respondent number 2, that is Assam Tea Corporation Limited, along with the private respondents. Therefore, A. Ganguly, the learned counsel appearing of information submitted you other further like to address the court. This court is, in fact, of the case is not inclined to extend the interim order. It is, however, made clear if any amount is disbursed, the same shall be subject to the outcome of the litigation. So this order itself gives us the right to disburse the amount. However, as an abandoned person, we have filed that, I guess.
Where is the interim order?
It's in the interim, there was an interim
No,
order.
let us see what interim order is not extended.
Earlier we have not annexed.
In where? In the main writ petition. Which one? 3366. Huh?
3366.
Okay. Order dated? No, you said last year you had paid 20, where is it?
Last 12 years, they are paying.
No, no,
We have stated.
no, that we have seen, that all the last 12 years you are paying at the rate of 20%. But is there any order in the last, so far as last year?
Yes, paragraph 10, in page 12.
Which IA?
IA P207.
Paragraph 12.
In compliance of the order dated 27/9/2024.
Hmm.
The PS offer is an amount of 28,64,474 on account of bonus of 20% of the year 2023 paid in the year 2024 to the workers of Adabali state out of the sale proceeds of 2.75.
7/9/2024. 7/9/2024.
Paragraph 3, page 12, the amount is 99,01,360.48 at the rate of 20%.
But this payment is not as per in compliance of the order dated 27/9. 27/9 we have seen. 27/9 has said the code-wide order dated 19/8/2024 had made it clear that if any disbursement is made, the same shall be subject to the outcome. Maybe you're taking leave of the leave of the order in taking not complete. You may pay, it will be subject to the outcome. Yes, Mr.
Yes, and here in paragraph 12.
Yes.
We see in for the Rajabari, for the Rajabari it is 2.46, which is when lying with that. In the other garden it is 5.04. 7.50. 7.57 crores 50 lakhs is now pending.
So that's what you say.
This way. In my mind, there is 450 lakhs. We are concerned about one packet, then 600 packets in respect of 2 gardens.
2 gardens, yes.
So we have put for lease.
Yes.
Leasing of this garden. Now, this packet garden will lease out, but there is a clause that if you lease it, one has to approve the financial registration for help. And according to ECL approach us, we have given for both the gardens, the margin money, the term loan is about 3.25 term loan. Plus cash paid facility we have given 4 crores. But somehow he could not run the garden for a period of 1 year. After 1 year, there is a due from the provident fund to pay. So ultimately notice have been given to pay, he could not pay. The garden was put for attachment. And subsequently decided for auction this particular land. And it was auctioned, it was sold. Now out of auction there is the same receipt, which they have received. And all have been kept with the provident fund, except finance their PFGs which are, and they have recovered. Now today I found that this we have given the what is the exact amount it is lying with them. that last time your lordship took is that we can produce before the court, what is the exact amount lying with them? Kindly see what is the exact amount lying with them.
Yes.
See, this garden. So far as my lord, the sale proceeds, the plea is stayed. Now if your lordship sale proceed, 6 crore, if your lordship got the plea,
Yes.
6 crores. And the amount adjusted against Lancer is 2 crores something. Bonus paid last year, 99,01348. And balance is 2 crores 95 is lying with them.
Yes.
And if your lordship now looks into. Yeah, these are all the claims below noted. Of the ATCL, all the claims, lordship has seen that all the claims. And if you see total is 3 crores 43,52,936.02. So if you buy then, nothing remains in this card. If it is prepaid, they have added all their unpaid dues for this period, FPTCL, bill, land revenue, salary of garden manager, all this has been added. So if you see the figures and see the balance which is lying with them, nothing remains and we will not be able to pay it. Now see kindly the next money of the next Rajabari. Rajabari again, sale proceed is 2 crores 75. Amount adjusted PF is 59,38,487. Bonus paid last year 28,64,472. So the balance is 1 crore 86,97,038. So if you add 1 crore 86 with this will nothing, it will not be big. So ultimate end of the day nothing will remain. This is one. Secondly, they have filed an application for pay bonus. Now, what is most important? Whether they are entitled, the workers are entitled to get the bonus. Yes, entitled. They are entitled to get the bonus, but not at the rate of 20%. That is our argument first. They are entitled to get a bonus of 8.33%. Maybe my lord, they have paid 20%, but under the law, I am saying they are not entitled. It has not been raised at a relevant time. That 20% whether 8.3. Now today we are raising that particular point. That under the law, they are not entitled. How? I will kindly take the basis of this.
Yes.
We have taken an objection earlier, affidavit also we taken an objection. Kindly see definition, section 21 of the Petition of Bonus Act. 221, section 221. See, salary or wages means all remuneration, other than remuneration in respect of overtime workers capable of being expressed in terms of money, which should in terms of employment, express or implied, were fulfilled, be payable to an employee in respect of the employment or a work done in such employment, and include dearness allowance, that is to say, all cash payments by whatever name or paid to an employee on account of a rise in the cost of living, but does not include so. So salary or wages, which remuneration does good, that has nothing to do with bonus. Bonus is being excluded. Kindly see Roman 4, kindly see man. Roman 4, kindly see. Roman 4, kindly see. There is a 221 Roman 4. See Roman 4.
Yes.
Any bonus, including incentive production attendance, so but does not include. Kindly see, but does not include. So my lord, bonus has been excluded. So there is nothing to do with salary or wages. Bonus has been excluded. Right, my lord, this is the revenue. Now please turn to the how eligibility bonus is under section 8. Section 8 is the eligibility of bonus. Section 8.
Yes.
Every employee shall be entitled paid by his employer in an accounting year bonus in accordance with the provision of this act, provided he has worked in establishment for not less than
30 working days in that. So entitlement is there. Every employee will get it. Under what provision by please see section 10 now. Payment of minimum bonus. Subject to other provisions of this act, every employer shall be bound to pay every employee in respect of the accounting year, commencing on any day in the year, and in respect of every subsequent accounting year, a minimum bonus which shall be 8.50% of the salary or wage earned by the employees during the accounting year, or 100 rupees, whichever is higher, whether or not the employer has any allocable surplus in the account. My God, typing mark this. My God, there is an entitlement of the employee. They are entitled to get bonus. It's a mandatory. But kindly see the word. Whether or not the employer has the allocable surplus in the accounting year, minimum mandatory one has to pay. You cannot. It's a legislature has entitlement. Yes, you have to pay. Provided the employee has not come this far. Now see 11. Payment of maximum bonus. Where in respect of any accounting year, referred to in section 10, the allocable surplus exceeds the amount of minimum bonus payable to the employee under that section. Employer shall in view of such minimum bonus be bound to pay to every employer in respect of the accountable year bonus which shall be an amount in proportion to the salary or wage earned by the employer during the accounting year, subject to maximum of 20%. So if there is allocable surplus, why not one the minimum bonus under 8.33% mandatory, it has to be paid. But it will, they are not entitled for the allocable surplus in an accounting year. What is allocable surplus? Now you see, my lord, allocable surplus has been defined in section 2.4. Section 2. Definition, section 2.4. Allocable surplus means in relation to an employer being a company other than a banking company which has not made the arrangement prescribed by the Income Tax Act for a declaration of payment within a year and dividends payable out of its profits in accordance with the provision of so and so 67% of the available surplus in an accounting year. Now, one of the kindly see, this is the year. So, if you have to see, now if it is a loss-making garden, there cannot be a profit out of it. There cannot be. You may have paid, I know, with great respect, I'm saying 20% may you have paid it. But when we come to the court, now I am saying that they are not entitled, but they are entitled to 8.50%. Allocable surplus has to be looked into the accounting year. It was a loss-making garden, that is why what you have leased out this garden. So my humble submission before your lordship is that, yes, under the act, you are right, yes, entitled to pay, but not 20% of the total amount which they have paid. It is only you are entitled to 8.50%. This is one submission which I made. They are not entitled under the statute. Under the statute, I am saying you are not entitled. Maximum 20%, but maximum 20% again, it has to relate to an allocable surplus.
Yes.
Right. Now, my lord will kindly see available surplus, section 5 kindly see, subsection 5 of 2, subsection 5.
Yes.
Available surplus, 6. Available surplus means that available surplus computed under section 5. Now, appropriate government means computed in relation to establishing district of research. So, in relation to any established government of the city under the established secret. Now, 4 and 5, kindly see section 4 and 5. See section 4 minus. Now, see section 4 of the payment of bonus act. Computation of gross profit
the gross profit derived by employers from an established in respect of the accounting year shall be, in case of banking company, we calculate the manner specified in the first schedule. B, in any other case, we calculate manner specified in the second schedule. Computation, now schedule your lordship will find. Is your lordship will find at the first schedule, computation of gross profit. So they have given how much profit, then only will be added 20%. Or this calculation they have to show. See the first schedule. Computation of gross profit. Now, second, first is banking, second is in respect other than banking. Kindly see the second schedule. See the second schedule. Computation of gross profit. Net profit as a profit and loss account. Here, tax provision for bonus to employees. Kindly see that. Depreciation. See directors. All this has to be taken into account. Then only we have to compute what is a gross profit. Then thereafter, section 5. Computation of available surplus. Section 5. See section 5. The available surplus in respect of any accounting year shall be the gross profit for the year after deducting them from the sum referred to in section 6. Provided available surplus in respect accounting year commencing so and so in respect of every subsequent accounting year shall be the aggregate of A, gross profit for that accounting year after deducting therefrom the sum referred to in section 6, and B, an amount equal to difference between direct tax calculated in accordance with the provision of section 7 in respect to event equal to the gross profit of the employer for the immediate preceding accounting year, and 2 is so and so. So all this has to be calculated. They have to arrive. Then only they are entitled to get 20. By making an application saying that yes, we paid for last 12 years and we are there, 20% is there entitled. We expect, I will say, 20% there won't be a ground of giving to the workers. Yes, they are entitled. And today I will say that minimum of equals 50%. Otherwise, they have to show before the court that yes, 20% we are liable to give it, they are liable to pay 20%, subject to fulfillment of this condition. Otherwise, section 10 is applicable, not section 10. 11 say 20%, allocable surplus available with them, but they have to show it. And now today, if this amount is released 20%, so tomorrow end of the day, your lordship decide what remains with us. These are also public money. These are also public money. And secondly, the upfront money is like with them. Lease period is like with them. That was for 30 years. 3.25 crores is like with them. Upfront lease payment, we have to pay 3.25 crores. It is like with them. If necessary, they can pay the amount from that amount, no problem. It is like with them. It was for a period of 30 years. These are all public money. It has been given.
Lying with them means lying with whom?
One is the upfront money has to be paid directly to the ATC, because when it is leased out, then there are two things. One is a term loan which you have provided. Now the ATCL says that no, if you want the lease, upfront payment has to be given to us. So then only you can run the garden. Lessee. The lessee paid the upfront money of 3.25 crores. That is a term loan which was given. Cash credit for running the garden over only is 4 crores here. So total we have given is 6.40 amount, which was given. Now he paid.
No, you are interested with the amount which is presently lying with the PF. If they make payment on their own, whether it's 3.8.3 or 20, you are you are interested in your, in the money which is lying in their account because you also have a stake in that account.
Yes.
You being the, you had given the loan.
From that, whichever, but now suppose it is touched from here, then end of the day, the very top, nothing remains in this. These
Okay.
are public money, we are accountable.
No, bonus will definitely consider, but we'll pass orders also. What would be the rate we'll have to decide. But why not the writ petitions being taken up for disposal? Matter ends there. Again, every year this question will arise, Mr. Saikia. A writ petition is by you. You are challenged what? The auction sale.
Which is lying with, here, entire it has been auctioned, we are entitled to get minus whatever peer dues are there. Those are public money, it is lying with them. This is what our case is. So whatever excess amount is lying with them, being a public money, it has to go back to the bank. This is what we are saying.
Okay.
We want the disposal of the case. Bonus is a different issue altogether. I am not proposing to my learned friends that we are not entitled, we are entitled to it. My humble submission.
No, there is a consensus so far as payment of bonus is concerned. The contention is only with regard to what rate. While Mr. Saikia is saying that last 12 years, 20% was the rate, you are saying that as per section 10 is the minimum bonus, 11 is the maximum bonus. And to pay maximum bonus of 20%, you have to be a profit-making unit.
Yes.
Yes, how do you respond?
Page 22, paragraph 5.
Of which order? Page 22. Which case? Paragraph 22, page 22, paragraph 5. Prima facie. Yes.
Upon hearing the learned counsel appearing on behalf of the parties, this court is not satisfied with the case set out. Court already taking into account the legit so. So the prima facie view of the court is that this case is not maintainable at all. Number one. Number two, Lordship, how can PNB dictate whether it should be 20% or 8.3%? They do not have any legal right to make that submit. Either they agree for the bonus to be paid or not to be paid. That is number two. They do not have any right to make any comment regarding the quantum of the bonus. Number three, Lordship, even if the bonus is paid at 20%, even thereafter also, surplus money will be lying with Provident Fund organization. Their submission is that this is public money, it should be with them. It is lying with the Provident Fund organization. And on top of that, any tinkering with the number of the bonus percentage, Lordship, that will, in my humble submission, that may be recorded, that may lead to law and order situation in the tea garden. It is not that I am trying to give a negative impact or a projection to before this honorable court, but that is the normal situation. If Lordship knows the spectrum of all tea gardens at the time of Durga Puja regarding the quantum of bonus, whether it is a government owned, private company or individual owned tea garden. Every year that is the issue. So even if he's paid a 20% bonus also, not if thereafter also there will be surplus amount which will be lying. Those figures are in paragraph 10 of both the IAs. So this is my humble submission. Otherwise also,
Okay.
if I withdraw this IAs also, then also that green signal is there to make the payment. Because they have not challenged that order till date, even after 1 year.
Rather, there is no restriction for you to make.
That is the view of the, I can withdraw this IAs immediately. The Lordship, in the Lord traveling Lordship to pass a detailed order.
No, since the aspect of 8.3 and 20 has come, we have to answer that, perhaps. Yes,
But
anything?
this is our case.
Yes.
So we have the right to withdraw it.
You can, if you want to withdraw, you can withdraw.
This is a gambling for me. Catch 22 situation. subject outcome is already there.
Yes.
We are not paying lots of the wages or whatever my learned senior friend was putting. We are very specific to the bonus.
See, Mr. Saikia, let me express it very clearly. If we have to decide on the percentage, we will have to decide in accordance with law by taking all your submissions. But this decision you're inviting this decision because of this application. If there is no application, then we'll not decide. Then you cannot object. If you want, you can object to withdrawal. Okay. Yes, who are you? What do you say?
In 4 crore 86 lakhs, we have got the KV in terms of the direction of your lordship. So balance amount I have taken.
Okay, heard. Sri D. Saikia, Learned Senior Counsel for Senior Counsel assisted by Sri B. Gogoi for the applicants in these cases. Also heard Sri D. Das, Learned Senior Counsel assisted by Sri A. Ganguly for the PNB. And Sri, your name? N. Patiri for the 80. For the 80 EPFO. Respondent was 4 and 6. By this application, directions were sought to enable the applicant to pay the bonus. At the course of hearing, reference to the Payment of Bonus Act 1965 was made, including the percentage mentioned. After hearing the matter at some length, Sri Saikia, the Learned Senior Counsel, has submitted that he would not like to press these applications, as there are already observations made by this court that any payments made in the meantime would be subject to the final outcome. In view of the above, the applications are closed on withdrawal. Okay. The writ petitions may be listed for admission hearing when? In the first week of December? When? October? Okay. In the fourth week of October? Okay. 30th of October, 30 October. 31st? Okay. On 4th of November. Okay, on 4th of November. Also heard Sri Sri Patiri, Learned. I called you, no, I called you. Sri Patiri, Learned, you are standing counsel. Learned Counsel has placed before this court the calculation sheets to show the total dues and the balance lying. Of the balance. I will let them. The said SHEET, SHEET, are kept with the records. No, balance sheet is with them only. Yes. It is only the sheet we are mentioning. No, we have not said anything. We have not said anything. You filed an application. In fact, this application could have come from you. That there is a apprehension of payment of bonus. We wanted it should be paid in this rate and not this rate. This has not come. Mr. Saikia has played a very wise move. Okay, last
23, very
last line to my ঠিক করে দিন কি ব্যালেন্স আছে yes You were in detention since when? When did we were taken into behind custody? Date
29/6/20.
29?
29/8/2021.
29/8/2021.
All co-actors have been enlarged on the lordship except this present petition. Search sheet was laid on 30/9/2021. Search was framed on 9/3/2022, lordship. Thereafter, lordship, only 3 PWs have been examined out of the 9 prosecution witness, lordship. The last prosecution witness was examined on 23/8/2023, lordship. Thereafter, no prosecution witnesses have been examined till today, lordship. Then lordship, PW1 is the scientific officer, 2 and 3 are the Caesar witness, lordship. 2 and 3 stated nothing against the present petitioner, lordship. And 2 and 3 in their cross-examination, lordship, they stated that they do not know the contents of the Caesar list, lordship. And they had put their signature on the Caesar list as asked by the police, lordship. Lordship, on 21/7/2025, lordship, the co-office number 5 was enlarged on bail considering the period of long incarceration, lordship. My humble submission is that, lordship, all co-accused have been enlarged on bail, lordship, except this present petitioner. Period of long incarceration may be considered. Last order was Annexa 11, case number 62, lordship. Date 21/7/2025.
Why last examination on 23/8/23? Thereafter, what has happened?
My lord, in the record, my lord, it is the last order is, my lord, 14/7/25. That date was fixed, my lord, 28/7. Thereafter, my lord, there is no order, my lord.
14/7, what happened?
47, my lord, that is fixed for evidence, my lord, further evidence.
Fixed on?
Fixed on, my lord, 28/7.
25.
Yes, that is in the record, my lord. And after that, my lord, there is no record.
Okay. And till now, how many witnesses?
Till now, my lord, as per record, my lord, 3
Out of 9.
out of 9.
Why not proceeded? Last witness was on 23/8.
My lord, that
23.
is, my lord, we can obtain, my lord, the status report from the honorable court, my lord. There, because, my lord, today is,
The other co-accused, they are appearing.
my lord, as per his instruction, my lord, there is that they are released on bail, my lord. But my lord said order, my lord, maybe. And my lord, my one respectful submission, my lord, that PWD 3, my lord, in his cross part, my lord, there is, my lord, he is clearly said, my lord, that the contraband was, my lord, recovered from that vehicle on which, my lord, the present petitioner is, my lord, traveling. Almost, my lord, 4 or 5 persons are there, my lord, and along with, my lord.
Let us
that-
see the previous orders of this court.
This honorable court, lordship.
One order is at page 69.
21/7 order at this honorable court. The executive order was 29/1/2024. Annexa 11. 21 order dated 21/7/2025. Case number 62.
So far as the other co-accused are concerned, which Senate Council has said that they have been released on bail, are they cooperating with in the trial?
My lord, regarding that also, my lord, record is silent, my lord, I have to.
Where are the orders of their bail?
Bail orders.
Bail
All
orders.
bail, all the co-accused bail orders are annexed.
Where? Page?
Page number. Page number 34. For Lordship Lulun Kuki. Page number 38 Kamkodip. Page number 45 Lordship Paumintang Langhal. Page number 56 Semintang Mete Lordship. Then 62 is for Koilanson Complaint. Fifth number co-accused Lordship. Dated 21/7/2025.
We are more interested to know whether the conditions imposed while granting bail to the other accused
Yes.
are being fulfilled or not.
Mm.
Okay. And also the reason as to why from 23/8/2023 till this date, there is not any further examination. This is from which court?
There is Karbi Anglong.
No. It is a two Lordship. Additional district and session court number.
Kamrup.
Kamrup.
Kamrup. You can get the information.
My
We'll have it immediately on the.
Now, my lord, then my lord, through registry, my lord, because it is in the honorable court.
Okay.
Everything was discussed on last 21/7/2025 dated.
Yes.
This honorable court has discussed all the thing which was going on in the trial process.
21/7 in this matter.
Yes. One Lulu Kuki was Lordship not cooperated. This case against his was Lordship split up on 19/5/2025.
One case is split up.
Not in this matter. In this matter, it's come up only for the second time.
Yes.
Which case?
Page together.
Case.
You are PP Bora.
Lordship.
Heard Sri PP Bora, learned counsel for the petitioner. Also heard Sri P Sharma.
B
Sharma, learned additional PP Assam. Full stop. The scanned copies of the case records have been transmitted, which have been perused. Sri Bora, the learned counsel, has submitted that out of 9 witnesses, only 3 numbers of PWs have been examined till date. And the last examination was on 23/8/2023. He has also informed that all the other co-accused have been released on bail. Considering the above, that status report, Sri Sharma, the learned APP, has submitted that on the examination of the scanned copies of the case records, the last date fixed appears to have been 28/7/2025. Filed and order dated 14/7/2025. Whereafter there are no records. registry is directed to obtain a status report from the concerned court of the additional district and session judge number 2, Kamrup, and specific instructions are to be obtained. Obtained with regard to the aspect as to why from 23/8/2023 till date, no witnesses have been able to be examined. Full stop. Information is also required to be obtained with regard to the compliance of the conditions, compliance with the compliance of the conditions by the other co-accused who have been said to be released on bail, which have been incorporated in the bail orders. Full stop. List on, we'll have it on 15th October.
My lord.
You're a local council or you come from somewhere else?
Yes, I mean.
Oh, then, okay.
Public.
Public.
I was saying. What's this? SBI.
There is no permanent council. We have contacted. There is no permanent standing council.
But you have served them dusty.
Yes,
Have you told this fact to the whom did you contact?
my lordship, the branch manager. My lordship.
No, whom did you contact? Which council? Not you either contact Mr. K. Das, no? K. He was there waiting for your matter. K. Das is there, then K. Nandi is there, and Shishi Dr. Senior Advocate. We can have your matter tomorrow or immediately on the reopening. You try to inform them. Okay?
Tomorrow, my lordship.
Tomorrow, have it on the reopening. We'll have it on 14th.
Okay.
Okay.
Fine.
The SB Laskar Learned Council for the petitioner has Mr. Das, you appear for State Bank of India.
Yes, I am.
You take information in this matter.
My lord.
We are requesting you informally. We cannot record your name since there is no standing council. Mr. Laskar will give you a copy of the petition. He has already served dusty. We'll have this on 14th.
My lord.
Court has submitted that pursuant to the directions of this court, dusty service upon the respondent bank was taken and an affidavit in opposition has been, and an affidavit in this regard has been filed on 22/9/2025. Full stop para. As there is no representation from the SBI, matter is adjourned
My lord.
to.
I am here. Then my lord, my name may be recorded.
No, we are not recording. We are not recording.
My lord.
It will not look good. Matter is adjourned to be listed on 14th of October 2025, by which date the bank may represent itself. In the meantime, you inform.
My lord, I will inform. I will. Okay.